Capital TV ready? Good evening and welcome to the Senate Judiciary Committee evening of March 12th. We do have a quorum. We have a number of items on our agenda this evening, and as has been the practice, how we're going to run the committee this evening is we are going to go through and let the sponsors of the legislation introduce their bills, and then allow questions from committee members to the bill sponsors, and then we will move into public testimony, and the members of the public have signed up to testify on the legislation that's in front of us. We are going to be keeping a 3-minute time limit for public testimony. There are, I know, rooms set up, TV set up down in the bell room for folks to testify for folks to follow along with the hearing. And if I do call your name and you're not in the room, and then you're down in one of the other places observing, just come up to the committee room and let the folks know at the door that your name was called, and I will let you testify when you're able to come up to the committee room. I would also ask for folks that are in the room, after you're done testifying, if you can leave so that we can have other folks who signed up to testify come in, so that we don't have too much of a lag between the testimony this evening. And with that, I am also, the majority of the bills that are sponsored tonight are from members who are on the committee or ex officio on the committee, and there are a couple bills that are sponsored by members who are in other hearings. So just as a note, I will defer when the other members come up to let them introduce their bills so that they can get back to their respective committees. With that being said, we are going to start at the top of the agenda, Senate Bill 2103, Leader De La Cruz, if you want to introduce your legislation. Yep.
Chairwoman.
Not a problem.
Just pulling up the agenda. Yeah, if you don't mind, I appreciate that. Thank you.
We're going to move ahead to the next bill, 2107, Senator DeLuca.
Thank you. This legislation allows for reciprocal carry. Many states have reciprocal carry laws, and we do not. I believe it's close to 30 states currently have these laws. This legislation would allow for reciprocity for those in other states. Someone who is able to get a concealed carry permit in Massachusetts should be permitted to carry here. We give full faith and credit to law in other states. In most areas of the law, we trust other states' courts, regulatory processes, etc. Why should someone not be able to carry a concealed weapon in Rhode Island if they are licensed to do so in another state? Thank you.
Thank you. Are there any questions for the bill sponsor on Senate Bill 2107? All right. Seeing none. Leader, we can go back to you, or we can move to the next. Okay. If we'll go back to Senate Bill 2103.
Thank you, Chairwoman. Bill 2103 provides an appeals process for individuals who have been denied a license to carry a concealed firearm. Currently, the only method of appeal is to appear before the Rhode Island Supreme Court, which can be cost prohibitive, and it also shines the limelight on an individual that might not want to be in that limelight. And in any other area of the law, you can appeal. So this one would provide an appeal process, and I'll just read my notes here. The way the law currently exists, if you are denied a concealed carry permit from a police chief or the AG, the only means of appeal is a writ of censure to the Supreme Court of Rhode Island. This is a discretionary in what the Supreme Court may or may not accept the appeal. If they do not, that is the end of the process. There is an appeals process to challenge just about every agency decision. Most of these appeals on a zoning issue or an issue involving the Department of Health, the Department of Labor and Training, so on and so on. And most of those do not involve an allegation of denial of a constitutional right. And in this case, the right to bear arms is guaranteed by the Second Amendment and the 14th Amendments that have no automatic appeal. It makes no sense, and it's unfair to our citizens to be forced to rely on the police chief or an attorney general to be the last say on an issue of concealed carry for any reason. This legislation provides an automatic appeal of denial of a concealed carry permit holder to Superior Court. Everyone deserves their day in court. There are no regulatory agencies where you are denied relief and are not entitled to an appeal. So why do we have that lack of appeal framework for the denial of a constitutional right? It may be that the applicant should ultimately be denied a concealed carry permit, but at least give the applicant their day in court. Thank you, Chairwoman Oyer.
Thank you. Are there any questions for the leader? All right, seeing none, I see that Senator Loria has joined us. So, Senator Loria, if you want to come forward, you have Senate Bill 2202. Welcome to the committee.
Thank you, Chairwoman and members of the committee. Good evening, colleagues. My life experiences as a healthcare provider and a mother have informed my commitment to reduce gun violence. The first 5 years of my career, I worked as a trauma burn nurse at Rhode Island Hospital. I have seen up close what a gun can do to the human body. I am fortunate, however, because I have never had to witness what a bullet wound looks like on the body of a child, and I hope that I never do. Unfortunately, far too many of my colleagues in medicine and emergency medical response have seen these horrific injuries because gun violence is the #1 killer of children in the United States. That bears repeating. Not cancer, not motor vehicle accidents, but firearms are the #1 killer of our children. As a society, we have poured immense resources into pediatric cancer treatment because no child should be lost to cancer if we can at all help it. We have passed and accepted mandates for seatbelts, airbags, and all types of collision protections for our vehicles because no child should needlessly die from a motor vehicle accident if we can help it. This bill seeks to offer similar safeguards for the #1 reason American children die: guns. In fact, I frequently will call this bill the seatbelt bill for responsible gun ownership. As a public health official, it is critical to me to have the data that identifies a health problem, as well as the evidence to back up the treatment or response. Please allow me to share some of that data with you. In the U.S., 4,000 children are shot and killed every year. 15,000 are shot and wounded. That's 53 children every day. Nearly 350 children under the age of 18 unintentionally shoot themselves or someone else every year. In incidents of gunfire on school grounds, up to 80% of shooters under the age of 18 got that gun from their home or the home of a friend or relative. Suicide by firearm has increased faster among children than any other age group in the past decade. 3,100 U.S. children, or 9 children every day, die from firearm suicide, and firearms account for nearly half of all youth suicides. 1/3 of youth gun deaths are from firearm suicide. In Rhode Island, 60% of gun deaths are firearm suicides, averaging 31 a year, an increase by 21% from 2012 to 2022. In 2020, approximately 77,000 guns were reported stolen in the U.S., and that is likely a conservative number, as only 15 states require owners to report lost or stolen guns. Greater than 50 of the nearly 40,000 gun thefts were taken from a car. Lastly, 54% of gun owners do not lock all of their guns securely, and 4.6 million children in the U.S. live in a home with at least one unlocked and loaded firearm. So colleagues, how do we protect our children from the leading cause of death in their age group? How do we reduce targeted school gun violence? How do we reduce children firearm suicides? And how do we reduce gun thefts? Research reveals that locking firearms and ammunition is associated with a dramatic reduction in all of the above. Bill S-2202 mandates the following. 1, all firearms must be securely stored any time they are not being carried or used by an owner. Guns must be stored in a locked container or secured with safety devices that prevent unauthorized use. It increases the age that an individual is considered a child from 16 to 18. It expands the education on the importance of secured storage of firearms by requiring licensed firearm dealers to display a warning about the risks of unsecured firearms and requires schools to distribute information about the same. Lastly, it requires that all guns, not just handguns, must be sold with a trigger lock. What this bill does not do is remove any individual's right to own a gun or use it in a lawful manner. It only acknowledges that with those rights come responsibilities to keep the weapon safely away from being used by children or those not lawfully allowed to have it. Gun violence isn't something that happens to someone else. We read of the tragic occurrences of shootings with unsecured firearms in all too alarming regularity. Children unintentionally shoot siblings, friends, or parents. Children bringing guns to schools and shooting their classmates or teachers. Children or adolescents feeling depressed and having easy access to the most successful method of suicide. It is time we educate gun owners of these dangers and equip parents and with the tools to ask the right questions. It is time that we insist on responsible gun ownership in order to protect our children. It is unacceptable that gun violence is the leading cause of death for children when we have the tools to decrease its occurrence. Thank you, and I would be happy to answer any questions.
Thank you. Senator Rogers.
Thank you, Chairwoman. One, possibly two questions. I get a lot of feedback. Number one, I'm a parent of a son who is a victim of gun violence. I'm
sorry to hear that.
I was the first one on scene when he was shot through the back of a window of a pickup truck, right down the street from my house. It hasn't changed my stance on my Pro 2, and it hasn't changed his at all either. Buckshot through the back window. He's still walking around with lead in his back today that you can feel. First one there. First question he asked me is, am I going to live? Being a little bit in the medical field as a first responder, I said, yeah, you're going to be fine. Now, I have been asked a lot of questions specific to this, and I'll use an example of how I'm asked towards you. I live alone with my wife. My kids no longer live with me. They're out. They live close, but they don't live in my house. It's me and my wife. Let's say I have a firearm sitting above my kitchen cabinet where you can see the butt, sitting right there. I have a medical emergency for my wife, and I call her. Fire and rescue come. Police come. They see that. Can I be charged with a crime if there's no lock and it's loaded and it's in my house and I live by myself with my wife and that firearm's sitting in my house? Am I breaking the law, and can I be charged with a crime?
Yes. Initially, it would be a fine, but yes.
So I'm a criminal. All right. We talk about statistics, and I know, not to belabor it, last year I asked a question, and when I asked the question on statistics, it was up through the age of 18 is when we use the statistics of children, largest killer, beating cancer and everything else. And I had asked if we broke out to what I believe an adult at the age of 18, because in the country we live in, we have a lot of gun crime with gangs. And if you break that, and I asked and I was told I would get that information, we're 1 year ahead, and I haven't received that information, if we took the actual adults out of that statistic from the age of 18 to 19 and see what that would do to the statistic, I believe it would evaporate. And I think that's why I haven't been given that information when I've been told I'll get it to you.
Senator, I haven't been able to find that breakout, so that's why you haven't gotten that
You
information.
won't, because I think it blows holes in the statistics of which we're presenting today. Not trying to attack anybody, it's just I've looked for it too, and I can't find it. So those are just two things I wanted to get out there. Thank you for your time and your commitment. Thanks.
Thank you.
Thank you. Are there, Leader Delacruz?
Thank you, Chairwoman. So I'm reading through the bill here, and it says here, a person who stores or leaves their firearm in any place. That seems a bit vague, because any place, I mean, does that mean right next to me on the couch? Then on line 8, it says storage of a firearm unless the firearm is secured in a locked container or equipped with a tamper. Now, for an individual such as myself who used to be alone at night and lived in the city, purchased a firearm for myself for protection. I had a bat under my bed, but I thought that's not going to be sufficient if someone breaks in. So I would sleep with a firearm beside my bed. Granted, I was single, I didn't have children. This seems like it would put a lot of women in a really tough spot if they had to lock up their firearm, wake up in the middle of the night to a burglar or a break-in, fumble in the middle of the night to find the key to their safe. That could be very dangerous for a woman. And then on line 12 it says, within such proximity. Again, vague. We probably should know what that proximity is. You know, is it if I'm at the kitchen counter washing sinks and washing dishes, and I have a firearm on the kitchen island? Is that proximity? Is it not? Is it up to the officer who maybe sees the infraction? Again, very vague. I think if you're going to propose legislation, it should be more precise, not open to interpretation. And those are the only three issues that I find at the moment that I'd like to bring to your attention for amending.
So if I could just respond to the concern about the woman who has a gun next to her bed, there are plenty of ways to secure a firearm that does not require a key. There are ones that have a fingerprint that literally takes less than a second. The fingerprint just has to engage and the lock falls out. So there are means to mitigate that concern.
Yeah, that may be cost prohibitive for some women, but thank you.
Are there any other questions or comments for the sponsor? All right. Thank you, Senator Luria.
Thank you.
Next up, I see Senator DePalma has joined us. And Senator Chacon, I'll take you next. Senator DePalma, welcome to the committee. Your bill number is Senate Bill 2653. Welcome to the committee.
Thank you, Madam Chair, members of the committee. Let me get my notes here. I apologize for being a little late. So let me start the intro to the bill you have before you. Let me start to articulate what it does, and usually I start with the why, but let's start with the was, and I'll do it in very general fashion since there's a lot of specifics in here. What the bill seeks to do is ban assault-style weapons. We'll talk a little bit later about definitions and what's considered there. For existing owners of assault-style weapons, they'd be allowed to keep those. They have to register them. I understand that might be a challenge, but they could keep those as long as they register them. And there are exemptions in the bill. There are exemptions for certain individuals or classes of individuals based on their prescribed criteria. Also, members, you'll see that in the bill. So that's what the bill on a macro level seeks to do. Let's talk a little bit about the why. And I'm going to focus just about all my time, the time that I'm here anyway, on the why. And Madam Chair, members of the committee, I will be here the whole night. I do need to go to finance. Finance is waiting for me to start, but I wanted to come here before we began finance. So as I indicated when we had the press conference on the package of gun safety bills, I'm not happy to have to do this, but it's necessary that it be done. Let me thank the committee for all you have done. Many of your members have looked at this for many years. what you are doing and what you will do to keep Rhode Island safe. I'm here to introduce something that's really about public health, let me shut this off, and safety. Something that's become all too commonplace approaching an epidemic. And I'm not going to be hyperbolic in my language because I'm going to go back to the facts and data here pretty quickly. But I think when I walk through the facts and data for you, I think you might come to that same realization. As an engineer, you always hear me talk about facts, data, the context for those facts and data, and then the personal story. And I'll end the personal story. I'll wrap it up at the end on the personal story for you. So there's some definitions people will want to challenge. What's a mass shooting consisted of? I'm not going to challenge that definition. That exists out there if you want to make it 5 or 10 people involved. You want to make it 3, make it whatever. We're going to go based on the definition that's been used so far. For the language description I'm going to talk about here, and I use the words appropriately, assault-style weapon, because some say that's not an assault weapon. Got it? Assault-style weapon. What are we talking about? Something like a military-style .223 Bushmaster semi-automatic rifle. And if you remember that, I'm going to get to that when I get to the personal story. And there's some other definitions as well we'll go through. I think it's important for the committee and the public to know that a supermajority, what's considered to be a supermajority in my name, sometimes more than 65%, 67% of our colleagues are co-sponsors on the bill. What does that mean? 67 equates to 25 sponsors. I think that's a supermajority of the Rhode Island Senate. Let's talk about a few more facts. From 2009 to 2022, 9 out of 10, 90% mass shooting incidents with the most casualties involve the use of at least one assault weapon. Fact, over 2 times as many people are killed when mass shootings involve an assault weapon, and 22 times more people are wounded. Research estimates, and this is research, and it's an estimating based on data in the past, so it's looking at interpolation and extrapolation out. If the federal law prohibiting assault and high-capacity magazines was in effect from 2005 to 2019, it would have prevented 30 mass shootings, which resulted in approximately 1,500 people shot and killed and wounded. If this happened to, and we can all look at what just happened recently, if this happened to a airliner went down for a particular reason, they would shut down that airline and that plane, that model of airplane in seconds. We all know what happened with the MAX 8, ultimately. We know what happened with the MAX 9. And if we know what's just happened recently with regards to the qualities that just came out this morning, there's a particular airliner that's into some serious hot water as it relates to quality control. Given the nature of this, we've not done anything. We, the state of Rhode Island, or the federal government for that matter, and I'll come back to that in a minute. 20% of the states have an assault weapons ban, including our neighbors, Massachusetts and Connecticut. We can imagine why Connecticut has it and when that came about. Let's talk a little bit about the Constitution. Like you, I took oath to uphold the Constitution of the state of Rhode Island, and most importantly, the Constitution of the United States. Rhode Island can't go beyond the Constitution of the United States. I'm just going to read the First Amendment for a second. Congress shall not make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of people peaceably to assemble and to petition the government for redress or grievances. The Second Amendment, which we're all familiar with, which is more applicable today, but I think they're both applicable. A well-regulated militia being necessary to the security of a free state, the right of people to keep and bear arms shall not be infringed. If I type those words correctly, I think that's what it says exactly. These are amendments to the U.S. Constitution, though they are not unlimited. They are not unlimited. They are with restrictions. For instance, one of us cannot yell fire in a crowded field. That would be one would say that violates the First Amendment. It's free speech. I want to do it. No, you can't. Likewise, we have limitations on the bearing of arms. The 10-year ban was passed by the U.S. Congress on August 25th, 1994, and signed into law by President Clinton on September 13th, 1994. The ban applied only to weapons manufactured after the date of the ban's enactment. Unfortunately, it expired September 13th, 2004. So we had a federal ban in place for 10 years. A federal ban in place for 10 years. This body, many of us were here, maybe in a different role. In 2022, Rhode Island banned high-capacity magazines. Rhode Island General Law 11-47.1-3. And I thank the Circuit Court of Appeals last week. The appeals court judges said that the ban was likely consistent with our relevant tradition of gun regulation, and this, most importantly, permissible under the Second Amendment. This is the court saying it. The court cited sawed-off shotguns as an example of similar restrictions on categories of weapons. The Second Amendment is not without restriction. It is not unlimited. The courts have said that. Our court has said that. The federal court said that last week. Some might say, well, it's going to go to the U.S. Supreme Court. As it stands today, the law of the state of Rhode Island is in fact upheld, that we passed several years ago. Once again, the amendments are not unlimited, they're with restrictions. People want to talk about, I'm an engineer, I'm not a lawyer or constitutional person. This is what the framers thought about. Whenever I hear that, I always like to know, how do you know what the framers thought about? Someone will say, well, I've read all these books. Well, I read books too. And I was given this book by my son-in-law that says, To Keep and Bear Arms, The Origin of the Anglo-American Right by Joyce Lee Malcolm. I'm not certain anyone can say for or against that the framers of the Constitution knew we would be here today. I'm not going to say that. So we can't say that they knew what might be possible. With regards to why, and some of us have had this conversation, why the Second Amendment is there, it's protection of ourselves against the government, right? I work in the defense field and have for 41 years. Weapons that the defense has, the government has, everyday Americans will not have and cannot have. It's just going to be the case. So there's a limitation already there at that level, and we already have limitations in Rhode Island general law. So I think the case for restrictions has been made. The courts have upheld it. They are not unlimited. I want to bring you back to your high school days. For some of us, that's a long time ago, myself included. Envisioning your teacher says, take out your physics book and turn to the chapter on energy, which is measured in joules, right? Remember, there's both potential, kinetic energy. What I want to focus on here is kinetic energy. Just bear with me for a few minutes, please, if you can. When we look at kinetic energy, the equation is 1/2 the mass of the object times its velocity squared, meaning how fast it travels. So we're talking about kinetic, and we're not talking about the potential energy is when it's at rest, what it has a potential to do. The kinetic energy is the energy that's exuded when it's moved forward, the particular object moves forward. So 1/2 mv squared. So I took a pretty conservative look at the size and mass of certain bullets. So in this case here, I mentioned earlier, the .223 Bushmaster, I almost forgot the name. So I said, well, let's go figure out the grains of the .223 bullet. Got that converted to grams. or kilograms, because that's what you typically do it in, and I converted that to kilograms. Also looked at and got and for the Bushmaster, on average, it could be about 0.005 kilograms, okay? 5 grams. With regards to the speed, the velocity of that projectile coming out of the Bushmaster style weapon, over 3,200 feet per second. I think it said 31. I rounded it up to 3,200 feet per second. In meters, that's 975.6 meters per second. That number gets squared. So remember that for a second. So it's 1/2 the mass times the velocity squared. I then said, okay, let's take our typical handgun. And I reached out to a local police chief to verify what I thought I would use. So I used a 9mm Luger. Same thing, 1/2, 0.5. The mass of that is bigger. I forgot the number of grains, but it's about 7.007 kilograms. The speed of that comes, and that's the high end, about 1,400 feet per second. 1,400 feet per second. So it's less than the 32 by half, right? So that equates to about 426.7 meters squared. Number of joules that will come out of that. At the end of the day, the velocity is what causes the increase in kinetic energy. There's different masses. In fact, the mass of a bullet coming out of a 9mm Luger, I think I used, if I had that correctly, was bigger by 40%, 30%. But the speed is half, roughly half in meters, less than half meters per second squared. The energy of that projectile coming out of the 9mm is 637 joules. Okay, well, you don't have to care what that number is for a minute. The energy of that projectile coming out of the Bushmaster that we talked about before, 2,379 joules. Almost 4 times. Almost 4 times. So when that projectile hits something, it's evaporating when it hits. It's evaporating when it hits. Because that energy hitting that, whatever that body is, 4 times the amount of energy when it hits whatever it's hitting. It's basically going to disintegrate it. Why do we have the casualties and wounded that we have with these weapons? That very nature. That very nature. So in summary, with regard to the physics side of things, the bullet from a military-style weapon like the Bushmaster XM15, I forgot the name, XM15, has 4 times, and I'll say it one more time, 4 times more kinetic energy than that from a typical 9mm handgun. I suspect, I look forward to being here later. I do have a few other things to say, Madam Chair. Folks are going to say guns don't kill people. People do. You're absolutely right, categorically right. This General Assembly, I've been involved in the Finance Committee for 16 years. We made some marked significant investments in mental health. Over $30 million and then some as it relates to the certified community health centers, clinics across the state. That's about to kick off, I think, in the next couple months. That investment's been made to address mental health. Mental health's a critical issue, absolutely. So we need to do it on both ends. Help the individuals so that somebody doesn't go do that. And also, by the way, disallow the ability for somebody to have a weapon with 4 times the amount of energy coming out of it. Forget about the speed by which the number of bullets can come out. So let's talk about the personal story. I'm not going to say his name right now, but we'll go with his name. Seven-year-old boy. Among 26 victims, December 14, 2012, 12 years ago. Shooting in Newtown, Sandy Hook. We're all familiar with it. I know exactly where I was when I heard it. Driving over the Braga Bridge, going east on the westbound side. And my wife, who's a now retired kindergarten teacher, thought of her away and let her know, because we're both from Connecticut. I'm from Bridgeport, she's from Trumbull. Newtown's not very far away. I'm just going to read this. This was part of his obituary. He was an amazing son, brother, and grandson whose heart was only filled with love for all the people he touched. Fun-loving, energetic boy, had a true love of life. He completed his first triathlon at the age of 6 and ran in many community road races. I just think about running in a triathlon, and I said, I'm out of here. I don't think so. He had a deep love for the game of baseball and enjoyed practicing with his father and teammates. The boy's name was Chase Kowalski. Today, he'd be 18, probably looking forward to graduating from high school. As I said before, I'm originally from Connecticut with many family members in Connecticut. A relative of mine lives 2 doors away from Chase's grandfather. I know his grandfather. I can only imagine what he and the family of 27 others had to endure at the hands of the mass killer using a military-style .223 Bushmaster semi-automatic rifle, the one I talked about earlier. I have a grandson that's 7. Chase's age. We can all put ourselves in that situation. Let me conclude, Madam Chair. I took enough of your time. I, for one, not going to let these hundreds of deaths, and especially Chase's go without seizing the opportunity to effect the change in Rhode Island general law, one which had previously been acted at the federal level for a decade. We're not blazing any new territory here. Connecticut has it. Massachusetts has it. Other states, some will say, well, does New Hampshire have it? No, they don't. 20% of the states in the United States have a ban on assault-style weapons. Some will say we need to wait for Congress to once again enact a national ban on the military-style .223 Bushmaster semi-automatic rifle. Not me. And why is that the case? Let me give you a few examples. What happened with Roe v. Wade? Supreme Court basically said, states, it's all yours. What's Congress done? 0. We talk about cyber data breach. There should be a single cyber data breach bill across the country. We have one in Rhode Island because we did it several years ago as a result of work that myself and Rep. Steve Ucci from the House were on a cybersecurity, data privacy, now AI task force. We have a cyber data breach bill in Rhode Island. How many are there across the country? Probably 50. Are they all the same? Nope. Are they similar? Yeah, they might be similar, but we don't have one. Should we have one? Yeah, we should. Let's talk about data privacy. Madam Chair of this committee, I think we'll be hearing a data privacy bill, I think. We should have it at the federal level. We don't. And let alone with regards to, I love our congressional delegation. They do a phenomenal job. We can't even get a budget passed until it gets to the 11th hour, and we got 3 minutes, and the governor's got to sign it. The president's got to sign it in 2.5
when it gets to the Supreme Court, it may be a totally different argument. And on that argument, it has been ruled in the past that you talk about cannons and guns, big firearms that we can't have and this stuff. That is true. But it also states any commonly, widely used firearm used for protection is protected under the Constitution. And that's what they're going to rule on. They're not going to rule on saying, hey, you can't have cannons, so you can't have this type of firearm. So that's kind of getting into the weeds. I'm just trying to put the other side of the picture on that. We talked about the federal ban on firearms. The FBI statistics have proven that there were no discernible differences prior, during, and after that it made any difference. We talk about bullets, 223, velocity, going through. I have a lot of firearms. And I'm sure when you call the police officer and some chief and talked about, a 9mm, I'll use that same example. Was it a full metal jacket? Was it a hollow point? I can tell you right now, I know what a 223 round is. And I know what a 9mm hollow point is. And if I was told that I had a choice if I was going to get shot by one, I guarantee you right now I'd choose that 223 over that hollow point 9mm. So there are different statistics, and I know a lot about that, shooting both the 223 and the 9mm. I already touched on the commonly used firearm, but I'm gonna bring this back to we passed a law on a mag ban, and everybody's gonna follow these laws. And that mag ban reduced the firearm to 10 bullets. I don't care what kind of firearm you have. You've neutered the firearm by having a 10-bullet maximum. You've neutered it. So that's, that is also important to note. If we're all following the law and we're only allowed to have a 10-round mag, how can you have an assault weapon with 10 bullets? Can't have a 30 in it anymore. It's only 10. So, I've sat up here since 2018, and I've slowly, and I'm being worn down. I really am, because it's the same thing every single year, and I'm gonna give it my best. But every single year, we slowly chip away. We have mag ban, we have ghost gun, we have multiple guns. Safe storage is coming. Every single year, we pass multiple bills, and it just keeps eroding and eroding. I mentioned earlier, I know what gun violence is. It's happened in my family, but there was an incident that happened not too long ago that if the guy chose the wrong door and my wife was around, she may have been using that very same thing you're trying to ban to protect herself. So that being said, that's all I have, and I know you've got other things to do, and I wanted to keep it short. Thank you.
Are there any other, Leader Delacruz?
Thank you, Chairwoman. Senator DePalma, I respect you as an individual. We've worked on legislation together, and I wish we were on the same side of the issue here. Unfortunately, we're not. But I want to bring up a couple of points, rebuttals, perhaps, to some of the comments that you made. Just first and foremost, this legislation bans almost every firearm that is in public use today. A semi-automatic is a handgun, it's a rifle, and it leaves very few firearms to be legally purchased by Rhode Islanders. So that's problematic. The assault weapons ban of, let's see, I've got a few notes here and there. The assault weapons ban that you mentioned that was in place, I just took a screenshot here of a federal study. The Department of Justice prepared a following report in 2004, and they found that they did not find any evidence that the ban had a significant impact on gun violence. Okay, so I just want to say that again, that it was the Department of Justice in 2004 found no evidence that the ban had a significant impact on gun violence. And that was during the Columbine shooting, which was awful, and I don't think we'll ever forget. And then going back to your First Amendment example, brings back to mind Bruin when SCOTUS held, and I'm just going to read it here for you. The constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guaranteed. We know of no other constitutional right that an individual may exercise only after demonstrating to the government officers some special need. That is not how the First Amendment works when it comes to unpopular speech or to the free exercise of religion. It is not how the Sixth Amendment works when it comes to the defendant's right to confront a witness against him. And it is not how the Second Amendment works when it comes to public carry for self-defense. It's clear. Our founders did not foresee Facebook. They did not foresee television. Yet our First Amendment rights apply. And so I would say the same for the Second Amendment. With time, firearms change. They become more powerful, more efficient, but they do not become illegal simply because of that. And then lastly, to your point, I know this is a controversial topic, but you brought it up, so I'm just going to say, the Roe versus Wade issue, it's not in the Constitution. It should have always been at the states. Guns, the Second Amendment, firearms are a constitutionally guaranteed right. So, no, it should not be handled at the state level. There should be broad protections for it. And that's all I have, Senator DePalma.
Thank you, Leader.
If I may, Madam Chair, Senator, just to make certain we're on the record correctly with regards to, not what you said was wrong, I didn't say anything with regards to reducing the amount of violence. I don't think, if I did, I apologize. I think the words I used were the result of the violence would be significantly reduced given the restriction on not having that particular weapon, given the magnitude and the lethality of that weapon, the damage because of the kinetic energy of that weapon. I didn't say it was going to be reduced. In fact, it's increased. I'm sure it's increased because of mental health as well. But one thing we should all be aware of, with regards to the like I said, we can all challenge the definition of mass shooting, make it higher, make it lower. Based on the definition from 2014 to 2023, we went from 272 of them and 17 murders there to 656 and 40 mass murders. Not going to go through and talk about all the, were killed and all that. You know, the piece, Madam Chair or Madam Leader, just this morning, if it didn't happen today, I wouldn't have known about it. You mentioned about Facebook, right? Congress is about to ban TikTok. Where's the free? They're about to vote on it, maybe. So that's in front of Leader Johnson in the House for various and sundry reasons behind it. I'm not going to go into the reasons behind it to do that. One would say that they can't if I pull the thread on the First Amendment. Thank you, Madam Chair.
Thank you. Senator Rogers.
One quick point, and I didn't mention, I did have it written down. We always relate to assault weapons to mass shootings. I think we all know the truth. Most mass shootings are not used with an assault weapon. Most mass shootings are done with handguns. But that's, I think 3% are used with assault weapons. The majority of mass shootings, 3 or more people, are predominantly handguns. So we kind of twist mass shootings and relate it to something that I consider the shiny object. But again, you mentioned mental health. And I don't want to go down there, but that is the big issue right there. So the largest, I'll repeat it again, the largest firearm used in mass shootings is a handgun.
So, Madam Chair, just to make certain the language was correct that I said, from 2009 to 2022, 9 out of 10, 90% of the mass shooting incidents with the most casualties, not mass shootings with the weapon, the ones with the most casualties. And I said it, I tried to outfit this, or the context at the beginning of the conversation was about public safety. The most casualties involve the use of at least one assault weapon. That's all, and that's a fact. Now, I'm not talking with regards to guns. Guns were used in the majority of them, but the ones with the most casualties had the assault weapon. Thank you, Madam Chair.
Thank you, Chairman. don't see any other comments or questions. Thank you.
I'll be back later if you need me.
Thank you. Senator Chacon, you have Senate Bill 2451. Welcome to the committee.
Thank you, Madam Chairman, members of the committee. This bill, if you please look at it, you'll notice that it's very specific. It states, a fee of $40 shall be charged and shall be paid for each license or permit to the licensing authority issuing it. So the chief law enforcement officer in the state of Rhode Island happens to be the Attorney General. He charges $40. So knowing that there are other municipalities that somehow are circumventing the law and you people have done nothing about it, I added more of a description to it. No city or town or other licensed authority shall be permitted to charge more than $40 the fee for this section. So basically what it's doing is reinforcing what's already the law, since we're allowing municipalities to circumvent the law. I will take any questions, but I also, after that, would like to make one comment on my former chairman who's downstairs in labor.
Are there any comments or questions for the bill sponsor? Leader Delacruz.
No question, just a comment. Great job. This is an excellent bill. I hope it gets passed.
Thank you. And then Chairman, go ahead.
I believe I was in the majority by not signing Chairman DePalma's bill, and there's a reason for it. You people heard assault weapon, you heard semi-automatic. The bill, as I read it, encompasses every single firearm that's a semi-automatic weapon. Now, for the people that are unaware, the assault weapon is a military-style weapon that has a switch that flips from semi-automatic to fully automatic. ATF, Alcohol, Tobacco, and Firearms, and the Justice Department, any weapon that fires automatic is defined as a machine gun, which is violation of the law. There is a fine of, I believe, if I can remember, $250,000 and 10 years in prison. So before you render any decision here, is it a semi-automatic you're talking about, or is it an assault weapon? And I'll take any questions.
Thank you. Senator Rogers.
Chairwoman, you may not know the answer to this. Was that a mistake? Was it overlooked? Or was it intentional?
As far as the bill?
That language being in there, anybody with any common knowledge on firearm knows semi-automatic is just about every firearm out there.
That's correct. I
So
believe.
back to my point was, do you think it was a mistake
No.
or intentional?
No, I think it was intentional.
Thank you.
I believe that it was intentional based on the fact that they really didn't understand what an assault rifle was under the law. Thank you.
Thank you, Chairman. Any other questions, comments? All right. Thank you. Next up, we are going to go back to Senate Bill 2108. Senator DeLuca.
Thank you. This bill is also referred to as the Constitutional Carry Bill. This legislation would permit lawful residents of the state of Rhode Island who are 21 or older to carry a concealed handgun without a permit, subject to a few limitations. They are not otherwise prohibited from possessing a firearm. The handgun carrier must possess a certificate of qualification of shooting proficiency, and the handgun carrier has a DEM certificate as well as a photo ID. Around 26 states are constitutional carry states. That is a majority. And we should join states like New Hampshire and Vermont, which are safer than states which have very strict carry laws, such as Illinois. Thank you.
Thank you. Are there any comments or questions for the sponsor? All right, seeing none, we'll move to Senate Bill 2111, Leader Delacruz.
Thank you, Chairwoman. This bill would provide a cause of action for prohibition of possessing a firearm. The legislation lays out the authority for a civil cause of action by an individual who suffers an injury on a premises that did not permit the carrying of a firearm on their own volition. So not by virtue of the state or federal law. But with the legislation, if a concealed carrier was at an establishment unarmed because he or she was following the instructions on a sign, gets injured because the criminal ignored the sign, the jury could very well rule that the establishment failed to ensure the safety of their patrons after requiring them to be disarmed to be on the premises. We all know that if a sign disallowing firearms to be posted on a restaurant, grocery store, car dealership, etc., a criminal with a gun will promptly ignore that sign. We cannot permit people and establishments to deny legal permit holders the ability to protect themselves and others. The only exception here, obviously, is with federal law, like post offices and state buildings, and on private property. So where it does apply is restaurants, grocery stores, establishments of those kinds.
Thank you. Are there any questions or comments for the bill sponsor? All right. Seeing none, we'll move next to 2201, Senator Rogers.
Thank you, Chairwoman. 2201, I got quite a few on, so I'm just going to make sure I got run. I'll read the definition on it. This act would define suitable person for the purpose of possessing and having, I want to make sure I'm right, 2201, yep. This act would define suitable person for purposes of possessing and having a concealed carry pistol permit. It would establish reasons for applying for a concealed carry permit for both in-state and out-of-state, and would recognize a concealed carry permit or license by a reciprocal state, and would establish what information is required on applications for carry permits, establish time limits and appeal process when an application is denied. It provides that records related to the carry permits and appeals is not a public record and would permit the use of silence or suppressors for the use in hunting.
Thank you. Are there any comments or questions for the bill sponsor? All right. Seeing none, Senator Rogers will jump next to 2216.
Get a lot of complaints where I live on. I live in a community that has many gun ranges, and sometimes some of the neighbors hear a lot of noise and has some type of complaint. But silencers will help dull that noise. Apologize. Dull that noise. So this would follow the federal law and allow the state of Rhode Island under the federal law to purchase them, as long as you're following that act.
Thank you, Senator. Are there any comments or questions on this bill? All right. Senator McKinney had to step out to attend to another committee, so Senator Rogers will jump ahead again to you, 2231.
This act would define suitable person for the purpose of possessing and having a concealed carry pistol permit. It would establish reasons for applying for a carry permit in both in-state and out-of-state residents, and would establish what information is required on applications for carry permits, establish an appeal process when an application is denied, and those records related to cash will be not public. That almost sounds like the other one, doesn't it? That's what it said.
Great. Any questions or comments on 2231? All right, seeing none, we're going to jump to 2676 by Senator Raptakis. This increases sentences for carrying a firearm when committing a crime of violence and for possessing a stolen firearm, and requires that a person convicted of these offenses serve a period of time in which they would not be eligible for parole or probation. And then next up, we have Senator Rogers again, 2199.
Man, it's coming at me fast. Like a semi-automatic weapon.
Keeping you on your toes.
2199, correct?
Yes, sir.
This act would allow an individual to lawfully possess a device that would silence the sound of a natural report of a rifle, shotgun, or hunting game to hunt game, as long as the host rifle and shotgun is allowed. That's the same as the federal one, but it would be in the Rhode Island statute would allow that separate from the federal. I had two of them in, just like you'll see I have two castle laws in, but that's what this one does pertaining to the state of Rhode Island, general law.
Thank you, Senator. Are there any questions or comments on 2199? All right, next we'll move to Senator Tokoyan and give Senator Rogers a little bit of a break. Senate Bill 2446.
Thank you, Madam Chair and members of the committee. I am introducing Senate Bill 2446 in collaboration with Representative Boylan's House Bill H7216, an act relating to criminal offenses and weapons. This act would help law enforcement solve crimes and work in a similar manner as fingerprints being submitted to the FBI's Automated Fingerprint Identification System, commonly known as AFIS. When an individual's fingerprints are taken after being arrested or undergoing a criminal background check, they are submitted to the FBI through AFIS. Those submitted prints are used to compare them against fingerprints collected from a crime scene with prints of individuals with a criminal record in their database. The National Integrated Ballistic Information Network, or NIBIN, is a system used for ballistic evidence similar to the analysis of fingerprints. When NIBIN is used universally, law enforcement realizes maximum benefits to solve and connect crimes. Essentially, this bill would require law enforcement agencies, in every case where a gun or shell casing is seized in an investigation, as defined in 1147-2, to comply with two requirements. The first requirement, the investigating law enforcement agency submit the firearm or at least two test-fired cartridge casings to the state crime laboratory or the Federal Bureau of Alcohol and Tobacco, also known as ATF, for testing. All departments, to my knowledge, do comply with this already. The second requirement is really the crux of this bill. Enter the ballistic fingerprints of the test-fired casing into NIBIN, the National Integrated Ballistic Information Network. This bill would require law enforcement from across the state to submit ballistic prints to NIBIN just as they enter fingerprints into AFIS. Rhode Island has two NIBIN systems in the state. One is located at the Attorney General's office and another at the same state crime lab located at the University of Rhode Island. To my knowledge, NIBIN is the only nationwide automated ballistic imaging network system in the United States that images crime scene casings and test fires or firearms that are illegally possessed, used in a crime, or suspected to have been used in a crime. The 2018 Working Group for Gun Safety report included a recommendation to ensure all police departments trace firearms seized in connection with crimes, then timely submit to the Rhode Island State Crime Laboratory for NIBIN analysis and follow-up. I would like to share with you a recent local investigation where NIBIN assisted the Providence Police Department and the Attorney General's office to solve a murder resulting in the defendant receiving double life in a drive-by shooting of a 20-year-old woman. Members of the committee, I've included in your packet a photograph on the top page of this young lady. A Providence man has been handed a 2-life sentence and an additional 50 years in prison for a drive-by shooting that killed a 24-year-old Warwick woman who was talking to a friend on a Providence street. The defendant was sentenced in January of 2024, following the June 2023 conviction for the murder and 9 other felony charges of Mia Brophy Bierman, a University of Rhode Island graduate who worked as a speech pathologist. On the morning of August 1st, 2021, Providence Police responded to reports of a shooting on Only Street and arrived on scene where Mia Brophy Bierman was taken to Rhode Island Hospital and pronounced dead. In the following days, investigators observed surveillance footage which showed a dark-colored sedan driving past the crime scene. They also recovered 2 9mm cartridges in the roadway. 4 months later, after this shooting, on December 12th, Providence Police conducted a routine motor vehicle stop of a Hyundai Elantra, in which the defendant was a passenger. Officers located a backpack that was tossed from the vehicle prior to the stop, which contained a ghost gun. Investigators ran this ghost gun through National Integrated Ballistic Information Network, NIBIN, database, which indicated that the gun was a possible match to the gun used on the August 1st, 2021 shooting. Experts did further analysis to confirm accurately. The findings determined the spent casings were from the scene of the Only Street shooting that were expelled from the ghost gun that was recovered. Just to clear up any confusion, NIBIN is not a registry, and it is prohibited from using to capture, share, or store ballistic images acquired at the point of manufacture, importation, or sale of a firearm. Rather, NIBIN is a tool used to aid law enforcement in solving crimes. Other states with similar NIBIN laws include Delaware, Illinois, New York, New Jersey, Nevada, and NIBIN just passed it in West Virginia, in addition to Kentucky having introduced a similar bill. This is a good bill. It's a crime-solving bill that will be used to apprehend, prosecute, and convict violent offenders. The key is to have all Rhode Island law enforcement universally enter ballistic prints into NIBIN. It's a good bill, and I urge the committee to consider it. I've also included in your packet a fact sheet from NIBIN, which is governed under the Bureau of Alcohol, Tobacco, and Firearms for any follow-up. And I'd welcome any questions. Thank you.
Thank you, Senator. Are there any questions or comments for the sponsor? Okay, seeing none, we're going to move to Senate Bill 2658 by Senator DeLuca.
Thank you. This is a Capitol Police bill. This legislation corrects what looks to be several inadvertent errors in the Firearm Act under Title 11, Chapter 47 of our general laws. The first part of the statute exempts police officers, sheriffs, fire marshals involved in investigations, and others from concealed carry permitting laws. It also includes state marshals, but doesn't include Capitol Police. It does this, again, when it pertains to exemptions from waiting periods for purchasing firearms for the same agencies, but does not include Capitol Police. We can all agree that our Capitol Police, who protect us here at the State House and in all the state buildings, including courthouse entrances, should be included in these exemptions. The glaring mistake is very obvious. Since we do not have state marshals other than state fire marshals, and they are explicitly exempt from these statutes. Just looking to correct this error and give the same privileges to our Capitol Police, who are among our finest and who attended the police academy and do an excellent job. Thank you.
Thank you. Are there any comments or questions for the bill sponsor? Okay. Seeing none, we're going to move to Senate Bill 2733, which I introduced on behalf of the Attorney General. What this legislation does is it disqualifies individuals with prior felony convictions from purchasing or possessing a firearm. Currently, under state law, the restriction is only in a very narrow category of felonies, and so this would extend this to all felonies. Happy to answer any questions. Okay, and then next up, we have Senate Bill 2734. Senator Basalian.
Thank you, Madam Chair. This is a bill that I've introduced alongside the Attorney General. I believe he has supported it in previous years. I am a strong supporter of this reform, which is particular to juveniles. What it does, it clarifies that it is unlawful for any person under the age of 18 to possess a firearm. Currently, Rhode Island judges, especially those within our family court, which deal with crimes involving minors, also known as individuals under the age of 18, are interpreting this statute to mean that a juvenile must have used the firearm in order to be charged with possession of a firearm. As I said, when charged with a crime, juveniles usually end up before our family court system. And on a tour of the training school a couple of Fridays ago, along with President Pro Tem Gallo, I was actually shocked and saddened to learn that most of the individuals now at our training school, our youth now at our training school, are there because of crimes involving guns, and because they're being charged under a different statute, it is now more willful and criminal conduct that is resulting in them being there. If we can lessen this restriction and allow the family court to charge and prosecute youth just for possession of a firearm, then maybe we can put them on a more remedial course that doesn't end up with a long tenure at the training school. So I support this legislation. Open to any questions as well.
Thank you. Are there any questions or comments for the bill sponsor? All right, Leader Dela Cruz.
I just have one question, and because I'm not a lawyer, so I generally don't know the answer. When a minor commits a crime, aren't their records expunged at the age of 18 and they have a clean slate?
It would depend. I'm not sure how that relates to this piece of legislation. But.
I guess I'll just have to reread the legislation and jot down some questions for you. Maybe I can catch you.
This doesn't deal with expungements.
No, I mean, for the crimes that they already have, right, if we're lessening the, if I'm understanding correctly, the crime is, I guess, dropped to a lesser degree. Is that correct, or am I wrong?
Right now, under this statute, juvenile firearm possession, you can only charge for possession and use. Mm-hmm. So what many of our family court judges are interpreting that to mean is that the firearm has to be used. This would strike that and use clause. It keeps all the same exceptions for hunting, supervision under a guardian, that sort of thing. But if a youth has a firearm that they should not have and merely is possessing it, right now judges are saying that they cannot charge for that. So this would allow them to charge for that.
I see. Thank you.
Or prosecute for that, sorry.
Thank you. Are there any other comments or questions? All right, seeing none, Senator Quesada will take your bill, Senate Bill 2788.
Thank you, Madam Chair. This is a legislation on behalf of the AG's office, another one from his office. And what this legislation does is to be able to, if anybody apply for a permit or a license to get a gun or a pistol, is to be able to check any record that was punched in the past for them to make sure that person never had a criminal record, anything violent in the past, and that's what this legislation would do. It's a very simple legislation. I will open to any question you may have.
Thank you. Are there any comments or questions for the bill sponsor? All right, seeing none, we're going to go back to Senate Bill 2218, Senator McKinney.
Thank you, Madam Chair. For the second year, I'm introducing a companion to a House bill that will expand the safety test requirement to purchase a handgun to also apply to the purchase of long guns. The 2018 Gun Safety Working Group that was convened by Governor Raimondo had recommended this. I'm
Obviously, having basic safety knowledge should be required of all gun purchases. Rhode Islanders who purchase a pistol must show a blue card showing they've passed the test, gun safety test, successfully. But to buy a long gun, there's no safety test required. And for that reason, we are introducing this bill. Thank you.
Thank you. Are there any questions or comments on Senate Bill 2218? Seeing none, we'll move to Senate Bill. Oh, sorry, Leader Dela Cruz.
I just had a question about what the safety test looks like, because currently, if someone goes in to purchase a firearm, they simply can't purchase it and walk out with it. They have to get a blue card, but they have to take a test in order to get a blue card and ensure that they know how to handle a firearm properly before they're granted that blue card in order to purchase a firearm. So how does this legislation differ from what we already have in place?
Simply adds long guns.
Are there any other comments or questions? Okay, seeing none, final bill for introduction, Senate Bill 2219, which is also Senator McKinney.
Thank you, Madam Chair. Another bill that we are putting in for the second year, along with the companion in the House, to limit firearm purchases to one gun purchase per 30 days. Laws that limit the number of firearms person can purchase within a certain time frame reduce the number of guns that enter the secondary market, weapons that are more likely to be winding up at a scene of the crime. And for that reason, along with the fact that multiple sales are often a significant indicator of firearms trafficking, and of course we know in Rhode Island we've had some high-profile cases that have involved large purchases within a relatively short time. Burrillville resident Ronald Andrechuk in 2021 purchased 169 firearms between July and November of that year. In 2020, Rashawn Mangum had lied about the theft of 52 guns from his home. It turned out it was actually 85. And he had visited 5 different gun shops in Rhode Island, often multiple times, spending at least $41,000 on guns and ammo between April and July of 2020. In fact, at one Woonsocket gun shop, it was more than $29,000 spent in a roughly 3-month period. Nothing wrong with spending a lot of money, but in this particular case, we are looking to join other states that limit bulk gun purchases. Thank you.
Senator Rogers.
Thank you, Chairwoman. For the sponsor, you mentioned the extremes. This is like taking a sledgehammer to kill a fly. We're talking about people that have bought hundreds and hundreds and thousands of dollars of ammunition, and you mentioned 3. And yet this blocks you for more than one firearm a month, correct?
There are a number of exemptions for law enforcement, government entities.
Of course there are.
Inheritance, licensed collectors, licensed private security companies, temporary rentals at gun ranges, participation in courses of instruction. So a number of exceptions as well.
In those exemptions, we see a lot of exemptions when gun laws pass. That's a whole nother discussion that I get frustrated about too sometimes. But we're talking about somebody like me or somebody who sometimes buys more than one firearm. I'm not anywhere near the 3 examples you've given. I think it's an extreme, going down to 1 a month. I think that shouldn't even be close to being. You should be able to do a little bit more than that. 1 a month is an extreme, and that's where I go back to. You're taking a sledgehammer and affecting a lot of people for a problem that is not a lot of people having a problem creating the problem in society we have. It's too extreme, is my point. Thank you.
Understood.
Thank you. Leader Dela Cruz.
Thank you, Chairwoman. So, Burrillville was mentioned. It likes to be mentioned. People like to mention it every time guns come up. But I will point out that the Burrillville police chief did his job, and he denied Andrechuk during the waiting period. It was a different town that did allow him to purchase multiple firearms. However, there's nothing wrong with purchasing multiple firearms. It's what you do, or if you're a danger to society. So I feel like that issue is moot. But when it comes to purchasing, let's see, hold on. You mentioned also that a lot of these firearms were stolen because he wasn't able to purchase, the other individual, not Andrechuk. Sometimes I make messy notes and then I can't read them. So anyways, I guess I'll just leave it at that. Oh, no, I found it. Sorry. So just yesterday, a California federal judge struck down the California state law, that one gun a month law, saying that it violates the Second Amendment. You can read the opinion online. It's posted there. But if I would dare say that if California, which is arguably bluer than Rhode Island, if their judge finds that a one a gun month law is unconstitutional, then, you know, it might be safe to say that it is actually unconstitutional. Thank you.
Thank you, Leader. Are there any other comments or questions for the bill sponsor? All right, seeing none, we have Secretary of State Omori here who would like to testify. Welcome, welcome to the Senate Judiciary Committee.
Good afternoon, Madam Chair, members of the committee. Thank you for allowing me to testify today. I am here in support of Senate Bill 2653 and Senate Bill 2202, the first which bans the possession, sale, and transfer of assault weapons, and the second which requires safe storage. I'd like to thank Chair DePalma and Senator Lauria for their sponsorship. For more than 30 years, I was an educator, a public school educator, and it pains me that we had to normalize lockdown drills and the fear that comes along with those lockdown drills because of acts of violence made easier by assault weapons. And I was here last year to testify on these bills. When I was first elected, I sponsored a similar military-style assault weapon ban. I was elected just before the worst school shooting in American history. And I thought that there needed to be mitigation. I explained that here last year. I still feel that way. I am not against the Second Amendment rights that Americans have. I am not against an American possessing a weapon. But I would like to give you just a little history. In 1934, in response to a high number of high-profile Prohibition-era gang-style shootings that involved automatic weapons and resulted in the collateral injury and death of innocent civilians, Congress passed the National Firearms Act, legislation that was backed by the National Rifle Association. It created a registry for machine guns and established a prohibitive tax on the manufacture and sale of automatic weapons. The vernacular of the time would refer to these weapons as Tommy guns. The law was passed with little legislative or public opposition. Americans knew there was a problem and supported this solution. Court challenges failed to overturn the law, and the vast majority of Americans do not consider this legislation to be an infringement on the Second Amendment right to bear arms. The National Firearms Act was reaffirmed in the Gun Control Act of 1968, and then strengthened once again in 1986 with the passage of the Firearms Protection Act, which banned the importation and manufacture of machine guns for civilian use. The National Rifle Association once again supported the 1986 legislation. In 2018, after the mass shooting at the Las Vegas Country Music Festival, the Trump administration, citing the 1986 law, issued regulations banning bump stocks. What has been outlined through this brief history that I've shared with you this evening is government policy enacted under presidential administrations of both Democrats and Republicans, 2 Democrats and 2 Republicans, that attempts to mitigate the negative impact of a certain type of weapon. The law has stood for 90 years and has not been interpreted as an infringement upon Second Amendment rights. In my view, the proposed military-style assault weapons ban introduced by Senator DePalma aims to address a similar issue to one that presented itself in the Prohibition era, mitigating the damage done in a growing number of mass shootings that take innocent lives, and make that much easier and create much more deadly damage. I believe that this law, which is similar to a law in our neighboring states, is good common sense gun restriction without taking away the rights of Americans to possess a firearm. And I'd be happy to take any questions if you have any.
Thank you. Are there any questions or comments for the Secretary?
Thank you very much.
Thank you. We are going to move to public comment now. And so, as I mentioned at the top, we're asking folks to leave their comments to 3 minutes. I know that it is a short amount of time and a number of bills, but we also, we all have been receiving emails. We received the written testimony. So if there's anything that you don't get to in that 3 minutes or a level of detail that 3 minutes do not allow you to get to, please feel free, send them as follow-up written testimony. We do review them. Our clerk is going to take a 3-minute timer, so when you do hear the timer go off, please wrap up your comments. Also, I will call the 3 people up to the table, and then I'll call the 3 people on deck so that hopefully if folks are in other parts of the State House, they can hear their names and know that they can head up to the room. So with that, I'm going to call up Colonel Bradford Connor, Steve Dambrook, Ed Troiano. And then next, we're going to have Tony Moratini, Jake McGugan, and Hillary Sammons. But we will start with these 3 gentlemen. Colonel, welcome to the committee.
Good evening, Madam Chair. My name is Colonel Brad Connor. I am the Chief of Police for the Warwick Police Department, and tonight I am here representing the Rhode Island Police Chiefs Association as their president. I'm here to speak tonight on Senate Bill 2202, Safe Storage of Firearms. We are in support of this bill, as it is a common-sense approach to keeping firearms out of the hands of children and those permitted from possessing a firearm. This is an important step towards preventing tragic accidents involving firearms, particularly those involving children and individuals experiencing mental health crises. Additionally, firearms not secured properly can be stolen and used in crimes of violence and can present a danger to law enforcement and the community. These measures are not intended to infringe upon the rights of responsible gun owners, but rather to promote responsible practices that prioritize safety for all. This bill still allows for the weapon to be carried upon the person or within such proximity that the firearm can be readily retrieved. Advancements in secure storage containers allow the weapon to be safely secured, but accessed by the rightful owner within seconds if needed for personal protection. This is certainly a bill that will make our community safer, and for that we support its passage. Next, I would like to add that the Rhode Island Police Chiefs Association does support the following bills submitted on behalf of the Rhode Island Attorney General's Office. Bill number 2733, which disqualifies individuals with prior felony convictions from purchasing or possessing a firearm. We support Bill 2734, making it unlawful for any person under the age of 18 to possess a firearm, and 2788, adding CCW applicants to the list of people that would be required to disclose expunged records. We have also submitted written testimony in support of Senate Bill 2446, which defines crime gun and requires law enforcement to submit casings for testing and tracing. Thank you very much for your time.
Thank you. Are there any questions or comments for the witness? Leader Dela Cruz.
Thank you for being here today. I didn't catch your name. I'm sorry.
Colonel Brad Connor.
Colonel Brad Connor, and you're the new president, right?
Yes,
I was
ma'am.
supposed to meet you, and I missed the opportunity, so hopefully we can connect at a later time. I just had a quick question for you. I don't know the answer, and so I'm hoping that you do. How many instances of a child improperly obtaining a firearm from either a parent, a friend, or a family member in 2023 in Rhode Island?
I don't have the answer to that.
Okay, thank you.
Thank you. Are there any other comments or questions for this witness? All right. Thank you, Colonel. Welcome, Steve. Go ahead.
Thank you.
Steve, can you just make sure the button is up on the microphone, or maybe need to move it a little bit closer?
I'm sorry.
No, thanks.
I'm here today on behalf of Attorney General Peter Nerona to support our Safe Storage Bill S2202. What the bill will do is allow us, both in law enforcement and in the mental health field, to be proactive versus the current state of affairs, which is reactive, meaning we don't have to wait as we do now until after the tragedy happens, until after a young man like Dylan Beans is shot and killed in Johnston, Rhode Island by an unsecured firearm. This bill allows us to get ahead, to prevent that tragedy from happening. So we're not offering condolences to the family of the victim, whether it be a death by suicide or some other criminal act. We're able to prevent that tragedy from happening. And this bill does that in several ways. First, it has an educational component. The bill requires gun dealers to display signage alerting purchases of firearms to the new requirements. It also requires the Department of Health and the state police to develop printed materials that will be distributed to gun purchasers and licensed dealers. And finally, it requires the Department of Health to develop materials that will be distributed in the schools to teach our young people and their families about gun safety and the requirements for safe storage. Prevention is the next step. And again, this allows us to get ahead of the tragedy, to intervene before it happens. But it doesn't just criminalize all of this behavior. And this is another way in which it's proactive versus reactive. In fact, the first two violations of the statute are civil violations, meaning they warn the person, look, what you're doing is not right, you're not properly storing the gun, and there could be tragic consequences. The first would require a fine of up to $250, and the second, a fine of up to $1,000. But neither of those is a criminal conviction. In fact, the first time that a criminal violation comes into play is if you commit a third offense. So you've been cited once, you've been cited twice, and yet a third time you're still not safely storing your weapon. In that instance, it's a petty misdemeanor, up to 6 months and/or $500. Now, if the gun is accessed by a child or a prohibited person, someone who should not have a gun, and that requires a misdemeanor penalty up to 1 year and/or $1,000, and that's if there's no injury or a crime is not committed. And finally, it only becomes a felony if the gun is not properly stored, accessed by a child or prohibited person, and that person uses the gun to commit a crime or causes injury to themselves or any other person. And then it's a 5-year penalty.
Thank you. Are there any other comments, or are there any comments or questions? Leader Dela Cruz.
Yeah, I just had the same question that I had for the chief there. How many instances of a child improperly obtaining a firearm, either family home, friend's home, or family member's home in 2023?
So we don't know the answer to that, Senator, because we're only notified, and the criminal justice system only kicks in if not only the child obtains access to the weapon, but then a tragedy occurs, like with Dylan Beans. So I can't answer the question because we don't have that data available to us. We only know when something bad happens as a result of that access. This would allow us to prevent the access to begin with, so we don't have to deal with those tragedies after the fact.
Sure. I have one more question. Thank you. So the answer is we don't have any of that data, so it's possible to say that there are 0 instances.
Well, no. In 2022, we know that Dylan Beans. No, we know that Dylan Beans.
In 2023?
2022.
Okay.
Dylan Beans was killed by a firearm that was not properly secured in the town of Johnston. So
Yes,
it's
I
not
remember that
0 for
story.
sure.
Yes, in 2023, but thank you, in 2022, that's true. One of the things that has been brought to my attention about prevention is, in some states, they provide education surrounding firearms to students. Like, what should you do if you find a firearm in someone's home? Like, you're at a friend's house, you're playing hide and seek, you hide in the closet, you find a firearm, what should you do? Some states have that kind of instruction for children so they understand not to touch it, to find a responsible adult, let them know. Is the Attorney General's office open to supporting that kind of legislation?
Certainly gun safety education or any gun safety initiative would be consistent with the Attorney General's position. It doesn't, however, relieve the necessity of this type of change so that we can be more proactive and prevent these type of tragedies.
Thank you. Are there any other comments or questions for Mr. Danbrook? Right. Thank you for coming.
Thank you, Senator.
Welcome to the committee.
Thank you, Madam Chair and members of the committee. My name is Ed Triano. I'm the current chief of the Bureau of Criminal Identification and Investigation for the Attorney General. I'm here today in support of Senate Bill 2653. I'm sure you're familiar with the bill by now, but it defines assault weapon. It defines the features of the assault weapon. It bans the manufacture, sale, purchase, and possession of assault weapons in Rhode Island with certain exceptions. My reason for support for this bill is simple. I believe it will help protect public safety and potentially save lives. And I make that assertion not based on a philosophy, a statistic, or a study, which I suspect that you'll be hearing many of those statistics over the next couple of hours, but I base it upon personal experience in over 30 years of combating violent crime and illegal possession of firearms in law enforcement. That experience is both with 25 years as a federal agent with the Bureau of Alcohol, Tobacco, and Firearms, as well as the past 5 years leading the Attorney General's Violent Crime Initiative. The conclusion that I've come to in my 30 years of experience, especially with firearms, is that there is no single piece of legislation or single action that is going to stop crime guns or the use of guns in mass shootings, but each additional layer of protection that we can provide to law enforcement and each measure that we can enact to prevent these guns from getting to criminals who do the wrong thing with them is effective. And so it's a matter of having those multiple layers of protection. And this is one of those additional layers. It will help to stem the flow of these guns getting out onto the street. Many of these guns, in fact, most of them start out being legally sold and then are eventually diverted to criminal elements. And so by allowing for the firearms that are currently owned to be retained by their owners, but preventing the future proliferation of these weapons out on the street will have an effect on the overall rate of violent crime. And finally, I will say that, again, I don't base my opinion on something that I've read or statistics or personal philosophy. I base it on the fact that I carried one of these weapons. I carried it for many years as part of ATF's tactical team. I know what they're about, and I know that I wouldn't, going through a door to serve a search warrant at 5 in the morning, I wouldn't want to be confronted with a bad guy with one of these guns in their hands. I thank you for your time and more than happy to answer any questions.
Thank you. Are there any questions or comments for the witness? All right, I don't see any. Thank you.
Thank you, Madam Chair.
So next up at the table, we have Tony Martini. We have Jake McGugan, Hillary Sammons. And then next after that, we'll have Sherry Sammons, Susan Moratini, and Melissa Cardin. Tony, we'll start with you. Welcome to the committee.
Thank you. That's on, right? Thank you, Chair Oyer and members of the committee for hearing my testimony tonight. My name is Tony Moratini. I'm from Bristol, and I'm a volunteer with the Rhode Island chapter of Moms Demand Action. I'm not going to go through the characteristics of an assault weapon, or Senator DePalma did a wonderful job of that, I thought, or the tragedies that can occur when you don't properly store a weapon. Instead, I'm going to recall a gathering from last week that occurred down in the State Library. 14 faith leaders from across 12 different faith traditions gathered to sign a statement stating as a moral obligation the need to enact the assault weapons ban and the secure storage bill. And while Bishop Henning couldn't join them, he did send along remarks reinforcing the necessity of passion, quote, a passage, quote, for the sake of the common good and the defense of human life. Because of this, the unprecedented nature of this gathering, to endorse this unifying statement, I'll repeat, the very leaders many of us, many of you, put your faith and trust in, declared in unequivocal terms the moral obligation to enact these bills. Because while thoughts and prayers are necessary, they're not sufficient. Only action is, your action. And it will take your individual moral and political courage to do so. Shockingly, Rhode Island has become a destination for the purchase of assault weapons because they're illegal in all the states that we border. Assault weapons aren't just a national problem. They're a local emergency. You must finally pass an assault weapons ban in Rhode Island to put this to an end and keep us safer. 2 years ago, a senior General Assembly leader and a grandfather, as am I, when asked why he supported the very hotly debated large capacity magazine ban, just upheld in federal court, as we heard Senator DePalma say, responded, referring to school shootings, "I'd be horrified if something ever happened to my grandchildren and I stood by and did nothing." A senior leader in your chamber said, "I'd be horrified if something ever happened to my grandchildren and I stood by and did nothing." Doing nothing is no longer an option. I urge you to vote the assault weapons ban and secure storage bills out to the full Senate with a recommendation for passage. Thank you.
Thank you. Are there any questions or comments for the witness? All right, thank you for your testimony. Welcome to the committee.
Thank you, Chair. My name is Jake McGuigan, Managing Director of State Affairs for the National Shooting Sports Foundation. We are the trade association for the firearms industry. I've submitted my written testimony in opposition of the one gun a month, 2219, and the assault weapons ban, and then also the mandatory locking of firearms, the S2202. I've been in front of this committee for many years, probably 15 years now, on this assault weapons ban. What has really changed in Rhode Island? Specifically, nothing. We can look back at a 15-year time period and see that out of 329 homicides, 2 rifles were used. That's 0.6% of the homicides here in Rhode Island. So I believe we're in a solution in search of a problem. But what has really changed in America? In November, an NBC News poll said that 52% of Americans either own one or have a member of the family in the household owning a firearm. 52%. We've seen a change in the demographics in America. 41% of black voters now say they own a firearm, a 17% increase in just 4 years. So why are we seeking to ban the most commonly owned firearm in America, the modern sporting rifle? Actually, in shotguns, as been mentioned by Leader De La Cruz and Senator Rogers, these are the guns that are going to be banned by this one feature test. Shotguns used for turkey hunting, bird hunting shotguns, Ruger 1022s, which are used in youth camps, 4-H and Boy Scout shooting competitions, Olympic firearms, all banned by the one feature test. That's going to be a problem here in Rhode Island. And again, it's not going to decrease crime. It's not going to decrease any of the issues that we see here in Rhode Island. As to the point on one gun a month, real quickly, as Leader De La Cruz pointed out, yesterday, a California judge issued a ruling, and the California law barring the purchase of more than one gun in a 30-day period was struck down and said it failed a test for state laws laid out in the 2022 U.S. Supreme Court ruling, the Bruin case, expanding gun rights. The lawsuit filed in 2020 alleged California law violated the Second Amendment and the 14th Amendment's rights to equal protection. So again, these bills, unfortunately, are not going to make Rhode Islanders safer, not going to make our streets safer, and not going to increase public safety. But we continue to spend time, effort, and resources addressing these issues. Thank you very much for your time today, and I will take any questions from the committee.
Thank you. Are there any comments or questions for the witness? All right. Thank you so much for your testimony. Welcome to the committee.
Thank you, Chairwoman, and thank you, committee members. Am I on here? Can you hear me? Can you hear? Okay, good. Yeah, thanks. I'm here today to support the storage bill, and particularly the banning of the assault weapons bill. I'm not a gun expert. My son was horrified that I was coming to testify today. I am the mother, the proud mother of a Providence police officer, a sergeant, who covers the South Side late at night. And I don't ask too many questions about his work because it's so freaking dangerous. I don't dare look at the news. But I'm going to tell you, when I got a text message a year and a half ago in February that said, "Mom, don't worry, I'm okay. I'm out of state." And I check the news and I see my very favorite police chief, Hugh Clement, pale as a ghost, and Perry saying it was the worst incident in their 40 years. It was in Wangskuck at 1 in the morning when a father took his kids and his grandchildren hostage. My son was the first one to show up with a fellow sergeant. He went in and negotiated next to a wooden door to get the grandchildren out. The kids were out. And what happens an hour later? They find out he has 15 guns. Rifles, guns. The news doesn't report whether they're assault or semi-automatic, but he's negotiating through the door to get kids out. How many incidents do we need? How many of these guns do we show in pictures? This is a mother of a cop's worst nightmare. You know, Senator Cohen. Probably talk to your mom. I'll get her over for tea. And I'm going to tell you, this is crazy. A day and a half later, I call him and say, how are you doing? Because I couldn't get through to him. He was exhausted and had other things to deal with. And he said, you know what the worst thing is, Mom? I can really relate to my fellow officers who've served time in Iraq and Afghanistan. Because at 100 rounds of weaponry, and I'm evacuating people from their homes in Providence, it felt like the Iraqi war. Rhode Island's not a war zone. We can't have our officers going in, just like this man spoke of, wondering what's in the other side of that door. We need to clean up our weapons of war and make sure our incredible officers, we have some of the best in the country, and Providence is awesome. We need to protect them as well as our children and our families. And no mother of a cop needs to be losing sleep, because I know my son will charge into Uvalde. He shows up every time there's a kid on a call. He'll rush in there, and he's going to lose his life as they shoot all these automatic weapons with him. I know it. So help us, moms, with our nightmares. It's got to stop. And that's what the president asked us to do. It's the least we can do in Rhode Island. We're a democratic state, God damn it.
Thank you. Next up, we have Sherry Simmons, Susan Moratini, and Melissa Cardin. And then on deck will be Michael Tillinghast, Jennifer Parsons, and Paul Levon. So welcome. We'll start on my right. Welcome. Just make sure that the button is raised on the...
Okay.
There you go. Thank you.
Thank you for having me here and allowing me to testify today. My name is Susan Moratini. I live in Bristol, and Senator Laurier represents my district. I'm here to support both S2202 secure storage and S2653 assault weapon ban. As a Moms Demand Action volunteer, I've had many conversations with parents and teachers worried about the threat of mass shootings happening here in a Rhode Island school. I've given gun locks to mothers, fathers, grandmothers, and women in abusive relationships, all worried about a loved one who owns a gun. I've met with veteran organizations and mental health advocates seeking to prevent suicides by guns. According to the CDC, the rate of gun suicides has reached the highest level in 50 years and accounts for more than half of all gun deaths in the United States. In Rhode Island, 60% of gun deaths are suicides. The trauma of gun violence is immeasurable, especially since becoming the leading cause of childhood deaths in America. Nearly one child gains access to a loaded firearm and unintentionally shoots themselves or another person, often a child, in the U.S. every day, for an average of 350 unintentional shootings. More than 700 children die by gun suicide every year. Along with school shooters, the guns used in these tragic incidents often belong to family members, relatives, or a neighbor. The need for secure storage of weapons has never been greater. Please pass both bills out of Judiciary and onto the Senate floor for a vote. And I just want to recognize that Dylan Vane's father stayed here for as long as he could, and Dylan Vanes was killed with an unsecured gun in Johnston in 2022. I don't think it matters if anyone died in 2023. The fact is, children do die when they access unsecured weapons. And I also want to say that Senator DePalma said 67% of his fellow senators are in support of the assault weapons ban. And Everytown did a poll of Rhode Island that was in the Boston Globe last July. And in that poll, over 70% of Rhode Islanders want these bills brought to the floor and passed. So the majority of people in the Senate and Rhode Island want you to pass these bills. Thank you.
Thank you. Are there any comments or questions for the witness? All right, seeing none, thank you for your testimony. Welcome.
Thank you. Dear Chairwoman Oyer and members of the Senate Judiciary, my name is Melissa Cardin, and I'm the Executive Director of the Rhode Island Coalition Against Gun Violence. We're a group of organizations, advocates, and educators who address gun violence as an urgent public health issue. Members and supporters include Kids Count, the Rhode Island Coalition Against Domestic Violence, the Nonviolence Institute, the National Education Association of Rhode Island, the Rhode Island AFL-CIO, as well as various and diverse faith congregations across the state. We are all in agreement that public safety is paramount in a civilized society, and we must be doing all we can to keep our communities and families safe from preventable gun violence. I'm here today in support of Senator Lauria's Secure Storage Bill 2202 and Senator DePalma's Assault Weapons Ban Bill 2653. On assault weapons, we must ask ourselves if we want to be the state where people come to buy these deadly weapons, or rather join our neighbors in Massachusetts and Connecticut and ban them. Many have said that we won't ban these weapons until we experience a mass shooting. Like many of you, we refuse to accept this. Polling shows that over 70% of Rhode Islanders support banning assault weapons. A majority of our state legislators and all 5 statewide office holders support a ban, yet this legislation hasn't been brought up for a vote in 11 years. On secure storage, we know that most school shooters get their weapons from home, and that 60% of gun deaths in the state are by suicide, which is why securely storing firearms is so important. The big lie is that a gun will make you safer. Data shows the mere presence of a gun in a household puts everyone in the house at 3 times more risk for suicide and at double the risk for homicide. Anger and easy access to firearms is a most deadly combination. Thank you for your consideration of this important legislation. It's time to vote these bills out of committee and send them to the floor. Thank you.
Thank you. Are there any questions or comments for the witness? All right, welcome to the committee.
Thank you for hearing my testimony today. My name is Sherry Simmons, and my senator is Megan Kalman. As a Rhode Island voter, I'm appalled at the lack of legislative action on the Secure Storage Bill 2202, held for further study last year, and the Assault Weapons Bill 2653, held for further study for the past 11 years. Over 70% of Rhode Islanders support an assault weapons bill, yet there has been no vote and no explanation. Massachusetts, New York, and Connecticut have passed assault weapons bills which undoubtedly protect Rhode Islanders. Inexplicably, Senate leadership has denied our elected representatives the same opportunity by refusing to hold a vote on either bill. The refusal to hold a vote puts Rhode Islanders in the path of inevitable tragedy and obscures information that voters deserve. In 2022, Senate President Ruggiero was quoted in the Providence Journal as saying, "These school shootings are horrific, and I don't see them ending." He also said he'd be horrified if something ever happened to his grandchildren like that, while he stood by and did nothing. While I commend President Ruggiero for calling for a vote on the high-capacity magazine bill at that time, there remains more to be done. Assault weapons are the weapon of choice for mass shooters, and firearm fatalities are the #1 cause of death for children in the United States. Those facts are horrific. Refusing to hold a vote on these 2 bills is the very definition of standing by and doing nothing. Although after learning this evening that 67% of Rhode Island senators support an assault weapons ban, it's no longer just standing by. is it? I urge each member of this committee to speak to the Senate President and demand a vote on these bills. Thank you.
Thank you. Are there any questions or comments for the witness? All right. Thank you so much. Next up, we have Michael Tillinghast, Jennifer Parsons, and Paul LeBon. And then on deck, we will have Reverend Jean Dishlewski, Mary Barden, and Patrick Crowley.
Is it Paredes? You said Jennifer Parsons. But
I did. What?
Is it P-A-R-E-D-E-S?
It could be, yep. We'll start with you, Michael.
Constitution law, and I happen to have paid attention in history class. Good afternoon. Thank you for taking the oath of office. Please do what you can by passing these bills to protect American children. I happen to have studied Constitution law, and I know that for a fact that when the right to bear arms was enshrined into the Constitution, it was alongside the language that said protecting and defending Americans from all enemies, foreign and domestic, when it was ratified. Tonight I am here with Dylan Vanes, the father of David Vanes. I'm testifying beside him, which he had to leave because he was distraught, unfortunately, in support of 2202 requiring the safe storage of firearms trigger locks. People can report there's guns missing as responsible gun owners and not face the consequences of this law. I met Mario, the man that David wants to prosecute for the death of his child, on the bus once. The first thing that he said to me was that he should be serving a long time in prison. The laws need to change to make that happen. This committee needs to pass this 2202 so that the judge can put this man in jail. Please pass 2202 to help secure firearms and allow David Vanes to see justice in court. Gun violence is one of the leading causes of death for children in the United States. Firearms and alcohol do not mix. Firearms and children do not mix. We want to see the Democrats do all that they can to protect American children from gun violence. Michigan passed a similar law after a firearm was secured to be used in a school shooting. On the other bills, constitutional carry makes the problem worse. Silencers purchased legally are the ones used in crimes. Women deserve an appeal process. My neighbor got an assault weapon in the mail pretty easily. A guy was selling swords that were longer than 3 inches at the Providence Place Mall. His store was shut down. I don't care about sportsman shooters. The Olympics should cut the sport. Guns had a significant impact on gun violence, so your statistics are very odd, and that concludes my testimony. Thank you.
Thank you. Are there any comments or questions for the witness? All right. Thank you so much. Welcome to the committee. If you want to introduce us,
Yes, sure.
Apologies on the last name.
No worries. Thank you for having me. My name is Jennifer Paredes. I live in Barrington, and Senator Pam Laurier is my senator. I am not a gun expert, and I am not a lawyer specializing in policy. I am simply a mother of 2 teenage sons who attend school here on Rhode Island, and I'm asking this committee to put the safety of the lives of Rhode Islanders above the right to own a military-style assault weapon and the right to store their guns insecurely. Gun violence has now become the #1 killer of teens and adolescents in our country. Not accidents, diseases, but guns. This committee has the power to help prevent a tragedy from happening. And as we've heard earlier, the majority of Rhode Islanders and senators are in favor of this. Please support Senator Laurier's Secure Storage Bill 2202 and Senator DePalma's Assault Weapons Ban 2653. Thank you.
Thank you. Are there any comments or questions for the witness? All right. Thank you. Next up, we have Reverend Jean Dishlewski, Mary Barden, and Pat Crowley.
Thank you, Madam Chair, and thank you, committee. I'm the Reverend Gene Dishlevsky. I'm pastor of Lime Rock Baptist Church in Lincoln, and I'm president of the Rhode Island State Council of Churches. I'm one of those faith leaders that Tony talked about earlier. I've learned that you don't have to be shot by an assault weapon in order to be harmed. You don't have to be shot at in order to be harmed. We're all harmed because of the threat of frequent shootings and the lethality when assault weapons are used presents a threat that we feel and we know. As a matter of fact, I know the threat is real when the Department of Homeland Security calls a pastor to have a shooter drill. I mean, really, the threat is real. We feel it and we know it. And we do things to mitigate, like the active shooter drills. My one concern is for children, that it is traumatizing for some adults to go through an active shooter drill. But it's also particularly traumatizing for some children. Not every child, but it's traumatizing for our children. If you can imagine when you were 7 years old, that you went into a clothes closet and we're told that you had to be absolutely quiet and not squirm or your life depended on it. That's traumatizing. It's me against the bad guys and I can't squirm? Whoa. It's harmful to many of our kids. It is frightening. The threat is there. The threat is something that we are all aware of. And we have an incident occur. There's some degree of anxiety because of the incident. And before we could actually calm down, something else happens. And we get more anxious again. And it's really hard to be able to calm down. We have a mental health crisis and a child mental health crisis in this country. This is something I think that contributes to it. So I encourage that you get the assault weapons out of the hands of civilians. Thank you.
Thank you. Are there any questions or comments for the witness? All right, seeing none. Mary, welcome.
Thank you. Press the button. Good afternoon. Thank you, Chair Oyer and members of the committee for hearing my testimony today. My name is Mary Barden, and I am the Executive Director of the National Education Association, Rhode Island. I am a 20-plus classroom educator who has worked and taught through the era of mass school shootings. When I first began my career in the mid-1990s, I could not imagine the grief, the trauma, the anger, and the frustration that holds us hostage in the classroom today. And I've experienced exactly what's talked about here, about having children have to huddle in a classroom. Since the school shootings in Columbine in 1999, when I was teaching in the classroom, there have been 394 school shootings, with the most recent approximately 66 days ago. I am here because we have to do all we can to prevent further tragedies. I don't want to look back and question what we could have done to save lives and prevent tragic injuries. Doing nothing is not a strategy. We cannot accept the status quo, and we can't say it won't happen here. Educators are exhausted watching the news and having doctors explain how assault weapons tear through tiny bodies, and we imagine our students, our colleagues, our children, ourselves in their place. Our current students have grown up in a world of mass shootings at schools, churches, grocery stores, and colleges. The impact of gun violence on schools can't be measured, and the impact of trauma on our students, our educators, and our families cannot be understated. We not only have to prepare for school shootings when these events happen, but we have to address them in the classroom as well, and are faced with the fact that adults have failed to protect children. Again. Students should not have to ensure active shooter drills to hide from mass murderers. Educators should not be forced to act as shields against assault weapons and make impossible choices about how to protect children. Unless you have experienced it, it is difficult to convey the trauma of an active shooter drill. No matter what the age of the students, from kindergarten through high school, these drills have a negative impact. They are associated with increases in depression, high anxiety, and psychological and physiological health problems. There is also the exhaustion of having to try to explain what these drills mean to small children, to special needs students, and for our education support professionals to comfort these special needs students during these drills. These drills are a frightening but necessary substitute for the meaningful action you have before you. An example of the impact is taken from research on the effect of school shooter drills. One mother's experience shows the heartbreaking reality and why she supports common sense gun legislation. She stated, "After a drill, my kindergarten son told me, 'Mom, I was really worried though, because the classroom baby chickens will chirp and tell the bad man that we're in there.' I started bawling, and that was one of the reasons I joined Moms Demand Action, because my son shouldn't be worried about the chickens telling the bad man where he is."
Please finish your final thoughts.
In conclusion, we are calling on you to support Senate Bill 2653 and Senate Bill 2202 to make sure our schools and our communities are safe for our children and our educators. Thank you.
Thank you. Are there any questions or comments for the witness? All right, I don't see any. Thank you. Welcome to the committee.
Thank you, Madam Chair, members of the committee. My name is Patrick Crowley, and I'm the Secretary-Treasurer of the Rhode Island AFL-CIO. And I'm here today testifying in support of Senate Bill 2202 and Senate Bill 2653. One of the chief roles of the labor movement is to make sure our members get an honest day's pay for an honest day's work, and that they can go to work and come home safely to their loved ones in order to enjoy the bread and roses our labor produces. But gun violence too often makes that impossible, because as powerful as that movement might be, our union cards aren't bulletproof. And we've seen this in every school shooting, every grocery store shooting, every street shooting, where teachers, store clerks, police officers, et cetera, working people, were the victims of someone else's rage amplified and unleashed indiscriminately out of the barrel of a gun. And it's not just our members who deal with the rage that they see, but we also deal with the consequences. It's union members who are the first responders. It's union members who are the transporters to the hospitals. It's union members that are waiting at the emergency room door to deal with the victims. It's social workers, it's grief counselors, it's union members and workers that are dealing with this trauma every day. Now, recently, the AFL-CIO conducted its own poll of Rhode Island voters on a number of issues. And we specifically asked a question about the safe storage bill that Senator Laurie has put in. Out of three, it was a poll conducted by Fleming & Associates, a well-known Rhode Island pollster. 80.9% of respondents supported the bill. Just 16% opposed it. 93% of Democrats supported it. 69% of Republicans supported it. 75% of independents supported it. The safe storage bill is a bill that has widespread support among the community. Why? Because it is common sense that you can't just leave a loaded weapon unattended. Bad stuff happens. We've seen it time and again. Assault weapons have no place in a decent society. They should be banned, and they should be eliminated from the streets and the homes and the workplaces of Rhode Island. Thank you very much for your attention, and for all working people, whether they're union or not. We ask you to support this legislation. Thank you.
Thank you. Are there any Leader Dela Cruz?
Thank you. Just love listening to the testimony. However, you said that there was widespread support among Republicans. That's not true.
Actually, Senator, when we did the poll, it was a spread of the registered voters in Rhode Island, not just union members, registered voters, And according to the polling data, 69% of Republicans in Rhode Island support the safe storage bill.
Please, let me finish my statement. I did not interrupt you when you were before the committee stating your what is it called?
Opinion.
Opinion, but also your poll. Okay. So I represent a district that leans red. And I will tell you that there are maybe a few handful of Republicans who may agree with the legislation. So few. And the overwhelming majority are very much against this legislation. And then I would go so far to say that the Democrats in my district are very much against the legislation. And then I'm going to just point to my very own family members who are laborers, who either were stonemasons, were laborers in the AFL-CIO at one point. They do not support the legislation. So I have to wonder, how was the question phrased to the individuals that you conducted the poll on? But in my experience, in my district, which I have a pretty good pulse on, they are not in support of this legislation. Thank you.
You're welcome, Senator. Just a couple of responses. 79% of union members that were polled support the safe storage. And quite frankly, as someone who has to deal with members that deal with analytical results as opposed to anecdote, I put my poll against your numbers any day.
I would like to see your poll, because many times people come before this committee with polls. They don't provide us the questioning, the data. And if you're brave enough to do that, then I will sift through the data, and I'll have a policy analyst sift through it as well.
Senator, you'll have it before I get back to the office. I'm watching the hearing in.
I appreciate it.
Thank you. Are there any other comments or questions for the witness? All right. Thank you.
Thank you.
Next up, we have Michael Kramer, Ellen Kellner, and Kelsey Bala. Welcome to the committee. Michael, we can start with you.
Thank you, Madam Chair. My name is Michael Kramer. I'm a resident of Providence. My senator is sitting up there. I'm a retired lawyer, and I'm a volunteer for the Rhode Island Coalition Against Gun Violence. I'd like to address the Second Amendment issue with regard to the assault weapons ban, because I don't think anybody should be misled by claims by the gun lobby that because assault weapons weren't banned in the 1700s, they can't be banned today. That's not the law. If it were, the Second Amendment would also protect the ownership of 50 caliber machine guns, sawed-off shotguns, bazookas, flamethrowers, and Stinger missiles, none of which were banned in the 1700s. Actually, the Supreme Court of the United States in 1939 held that despite the Second Amendment, sawed-off shotguns could be lawfully banned. The Heller case, which you've heard about, I'll quote Justice Scalia, because the right to own guns, bear weapons, is not unlimited. Justice Scalia wrote, and I quote, "Like most rights, the right secured by the Second Amendment is not unlimited. It is not a right to keep and carry any weapon whatsoever and for whatsoever purpose." After the Heller decision, 5 separate United States Courts of Appeals ruled that state assault weapons bans were lawful under the Second Amendment. Then in 2022, we had the Bruin decision. Since Bruin, the Supreme Court has not ruled on this, but one Circuit Court of Appeals has. The Seventh Circuit Court of Appeals in Chicago held that assault weapons were, and I quote, "dangerous and unusual weapons," end quote, "not primarily for self-defense," and the court upheld Illinois' assault weapons ban. 4 U.S. district courts in Illinois, Delaware, Oregon, and Rhode Island have upheld bans on assault weapons or high-capacity magazines. In fact, as you just heard, the First Circuit Court of Appeals in Boston just last week affirmed the decision by Chief Judge John McConnell that the high-capacity magazines could be banned. The law that you all passed 2 years ago is constitutional and does not run afoul of the Second Amendment. If you read that decision, and I urge you all to actually read it, lawyers and non-lawyers, the words assault weapons could replace the words high-capacity magazines throughout the opinion, and it would read exactly the same, with that court clearly signaling what it intends to do the first time an assault weapons ban comes before the court post-Bruin. So read the cases yourself, because the T-shirts about the Second Amendment are wrong. No assault weapons ban would infringe on someone's Second Amendment rights.
Please finish your final thoughts.
So both your constituents and common sense, as well as constitutional law, support an assault weapons ban. Thank you.
Thank you. Are there, Senator Rogers?
Thank you, Chairwoman. Again, I had spoken about this earlier, and you mentioned it, so I want to reiterate the Constitution. The federal government banned sawed-off shotguns, and it was held by SCOTUS on sawed-off shotguns. And I want to revert back to yes, because it is not a commonly used firearm in self-protection in the United States. So that's why they ruled on that. When we talk about many of the guns that's going to be banned in this assault weapons, they are commonly used in the United States for multiple things. That wasn't a question. It was just a statement. So thank you.
May I respond?
I'd actually like to hear your response.
I suggest, Senator, that you read the First Circuit Court of Appeals decision last week, and you read the Seventh Circuit Court of Appeals decision in Napier on the issue of common usage. Don't take my word for it, but both of those cases will surprise you as to what the Second Amendment does and doesn't protect. Read it.
Senator Rogers.
Yeah, we can go on and on. I guess that's how we're going to play this. So again, it hasn't been ruled. This assault weapons ban will make its way up. The First and the Ninth Circuit have made determinations, but it has not gone all the way up. And I believe when it goes all the way up, it will be issued as a commonly used firearm and be held unconstitutional. Thank you.
Thank you. And Mr. Kramer, I know that you've sent us some materials via email, so if you have any additional follow-up, if you want to email it to the committee.
Thank you, Senator.
Thank you. Welcome to the committee.
Thank you very much, Chair Oyer and members of the Judiciary Committee. I was actually going to pass on reporting today because much of what I have prepared has already been said. But I really had to come up and let you all know that I am a proud Democrat from Gloucester, Rhode Island. And all of my friends, who are also Democrats, all support these two bills that we're talking about today. Mainly, that's 2202 and 2653. So I just wanted to maybe throw in a little correction for the anecdotal evidence that was presented by my senator, Jessica de la Cruz, to let you know the other side of the story. I live in Gloucester, represented by Senator Jessica de la Cruz. I have been a volunteer with the Rhode Island Coalition Against Gun Violence since the massacre at Sandy Hook on December 14th. My grandson was 6 years old at that time, and I could completely empathize with the horror of the Sandy Hook community experiencing losing 20 children and 6 adults on that tragic day. The same grandson now is ready to turn 19, and I've had a wonderful 12 years with him. That the children who lost their lives in Sandy Hook have not been able to enjoy the same 12 years. It was after that shooting I was compelled to take an active stance against the proliferation of guns in our state of Rhode Island. There have been 394 school shootings since Columbine in 1999, and over 300,000 children have experienced gun violence in schools. Add to that all the lives lost and people injured when shot in grocery stores, theaters, festivals, parades, on the streets, churches, synagogues, mosques. The Rhode Island Coalition Against Gun Violence represents 50 partner organizations. You heard of some of them by Melissa mentioned in her testimony, all of whom join us in supporting common sense gun laws. And you also heard that the polls show 70% of people in Rhode Island support these laws, and we were happy to learn today that 67% of the senators support them as well. With such commanding public support, I implore you to pass these two bills out of your committee and onto the Senate floor, where they are guaranteed to pass. It is a travesty that we are surrounded by states that have banned assault weapons, and yet our General Assembly leadership is still in the iron grip of the gun lobby. I beseech the Senate Judiciary Committee to vote in favor of these two bills and release them to the House floor for a full vote by its members. It is a morally right stand to make our states safer. Thank you.
Thank you. Are there any questions or comments for the witness? All right, I don't see any. Thank you so much. Welcome to the committee.
Good evening, Madam Chair and members of the committee. My name is Kelsey Bala, and I am a policy analyst with Rhode Island Kids Count. Thank you so much for the opportunity to provide testimony today. Rhode Island Kids Count would like to voice its strong support for Senate Bills 2202 and 2653, which would require the safe storage of firearms and ban assault weapons. Firearm-related injuries remain the leading cause of death in the U.S. among children and youth. Nationally and in Rhode Island, gun reform remains a key area of focus, especially in the wake of devastating mass shootings. Rhode Island Kids Count believes comprehensive state policies to reduce gun violence can be expanded to help increase the safety of children in Rhode Island, and believe that Senate Bills 2202 and 2653 are practical steps to reduce senseless gun injuries and deaths. In Rhode Island, between 2018 and 2022, there were 147 emergency department visits, 17 hospitalizations, and 11 deaths of children and youth for gun-related injuries. Keeping guns unloaded and locked, as well as storing and locking ammunition separately, reduces the risk of gun-related injury and death by suicide and homicide. In the U.S., firearms are the reported cause of death in 1/3 of suicides among kids ages 10 to 14. Approximately 80% of firearm-related suicides take place in the home of the youth or a relative, with the firearm belonging to a member of the household in 90% of cases. Additionally, 67% of shooters and child unintentional firearm fatalities were either playing with or showing the firearm to another person when it discharged. Among child firearm fatalities with known storage information, firearms were often stored, loaded, and unlocked over 70% of the time in both cases. Furthermore, assault weapons were used in the 7 deadliest mass shootings in the last decade, and this is uniquely a U.S. issue. American children and youth are 21 to 23 times more likely to be killed by a gun than their peers in other higher income countries. And 10 states, including Connecticut and Massachusetts, have legislated bans on assault weapons. Both the safe storage of firearms and instituting a ban on assault weapons are American Academy of Pediatrics recommended policies, and we strongly urge passage of both bills. Thank you for the opportunity to testify.
Thank you. Kelsey, right? Yes. Yes. Any questions or comments for this witness? Thank you very much. The next panel will be Michael O'Neill, Frank Sicoscio, and Curtis Julio Alvarez. Are we missing Mr. Julio Alvarez?
That's me.
Okay. We're missing Michael O'Neill then? If someone could ask for Mr. O'Neill in the hall? Fine. Frank, why don't you go ahead?
All right. Good evening, everyone. My name is Frank Sicoscio. I'm the president of the NRA in Rhode Island. I want to say in general on this, both the House and the Senate committees, it's actually very disingenuous for you to actually start limiting the experts on these bills to 3 minutes. Your job as representatives and as senators are supposed to hear from both sides, the good and bad on these bills, and you're supposed to be able to ask questions of people that have knowledge on these bills. What you're doing on 3 minutes, limiting experts, is absolutely terrible on these bills, but I'll go forward on this. First bill I want to talk about is the safe storage. The language of the bill is terrible. It's actually vague, and it's going to be subjecting people to be able to go to court and challenge whether a firearm was actually in their immediate custody and control. This bill should not be passed the way it is because the language is subjective on that. It's going to cause a lot of people to be going back and forth to court. The next one's the assault weapons bill. We had an assault weapons bill all across the nation for 10 years. 2 governmental agencies, separate governmental agencies, did an extensive research on this. Both of them came back with the exact same thing. No measurable decrease in crime based on that. And this bill is 10 times worse because it only goes to 1 feature. So it's not going to do anything on that. There's another bill that's been put forward where they want law enforcement on anything that they consider a crime gun. 2 rounds of that have to be brought forward and have to be tested and part of a database. What that does you don't have any of the language, you don't have any expert that testified on that. What that bill is going to create an individual, if they are charged with a crime, every one of their guns is going to be put on a database. So is that individual with the FBI and the ATF. It's also an unfunded mandate for your police officers. Where's the money going to come for that? Now, if somebody's cleared of all the charges, are they coming off that database with the FBI or the ATF? No, there's nothing in the bill on that. So this is a roundabout way to make sure that if I'm ever charged with any crime or anything, even if I'm exonerated, I'm still on a government list on that. You need to make sure you check the language on that. There's also a bill that's been languishing for 6 years, and it's very disrespectful. The Capitol Police right now that protect you every single day and are downstairs right now carrying a firearm, because of the language of Rhode Island general law, we don't have marshals anymore. We have Capitol Police. You refuse to pass that bill that give the Capitol Police the same protection that every law enforcement officer does. You walk by those officers every single day, but you won't pass that bill to put them under the same protection of every other police officer. The AG has also put forward a bill for the expungement of criminal records to change that. Want to know why the AG put that in place? Because I challenged them and took them to the Rhode Island Supreme Court, and they lost. The Attorney General's office was utilizing documents that were actually sealed by a judge and ordered expunged. They were using those sealed documents to deny people their constitutionally protected Second Amendment rights. They got caught doing that. Now they want to put a bill in place to say that they can now go around the judge's order, even if they're ordered, those documents are sealed or expunged. That bill needs to die. That one you need to take a good look at. I'll tell you, every year we come here and we fight on these bills, and it's the same thing. I think it is incredibly disingenuous for the House Judiciary and the Senate Judiciary to limit people. You have people have great experience in firearms and can educate you on what's good and what's bad, and you don't do it. You're limiting people to 3 minutes. How could I talk on 19 bills in 3 minutes? What information in specifics are you going to get? And you are going to be voting on this, affecting people's constitutional rights, criminal law, Capitol Police, children's safety, and no one is asking the experts a really good opinion on this?
Thank you for your testimony. Leader Dela Cruz.
I have a couple of questions, but I'll just start with the one. Can you tell me a little bit more about this expungement? It was one of the bills that I had a question about, and I didn't know this was something that came about with your interactions.
There's a case you can take a look at. It's called Peter Montequillo versus the Department of the Attorney General's office. Peter Montequillo was involved in a shooting. Somebody came into his place of business, and that person tore the place up, went out, assaulted a couple of people. He had a concealed carry weapons permit. Never fired on the person. There was lots of security cameras there. When the police came, they actually seized Mr. Montequillo's firearm. They pulled his CCW. And then when they looked at all of the videotape, on the first pretrial in district court, they dropped all the charges and exonerated him, saying he was protecting the other the people in his facility. Never fired the weapon at all. What ended up happening is, when he went to court, he filed a motion to have all the records sealed. The Attorney General's office had a copy of those documents. When he went to go get his permit back, the Attorney General's office, looking at those documents, said, no, you utilized your firearm. Well, we can't give you your gun back. We can't give you a concealed carry weapons permit back. I took the case to the Rhode Island Supreme Court. The Rhode Island Supreme Court talked to the Attorney General's office who were there and said, you're utilizing documents that a judge had ordered sealed. You were served with that order, and you were still utilizing documents which, by the way, exonerated Peter Montequillo, and yet they still were using them to deny the reissue of his concealed carry weapons permit. In that case, we won. He now has his permit back because of me. The Attorney General has now filed a bill to amend that section of law, so no matter what the judges say in Rhode Island, they can still utilize documents and they can still use reports. Even though those reports are unfounded allegations, they were never pressed in court and never determined to be true or not. So somebody could be charged with a crime or made an allegation against. It's never been processed, never been brought forward by a judge. The Attorney General wants to be able to look at those and go, oh no CCW for you. They want to go around that, even if they were ordered by a judge to seal those documents.
Senator Rogers.
Thank you, Chairwoman. We did ask for a small amount of experts to have 15 minutes. That request was sent up to this floor. We never got a response back on it. So I'm concerned about it also. But you did mention on the assault weapons that how it's poorly written, and one item on it would be specific. You referenced to, with that, it kind of piqued my curiosity of what you were talking about, where that assault weapons ban, how it's written in this state, would cause a problem. Could you elaborate on that?
I was talking about the wording of the safe storage bill.
All right,
what ends up happening with the safe storage bill is, if a firearm, even if you have a concealed carry weapons permit, you don't have it on your body, the way this bill is written, if that firearm is not in your immediate custody and control, you could actually be charged on that. Whether it's initially only $250, then it goes up. But the question was posed before to the sponsors of the bill in the other chamber, and what happens if at night you have a firearm that you carry and you utilize for self-protection in your house, and it's the only one that's out, and you get a knock on the door, and you put it down, and you go across the room or go to the next room to open the door. That firearm is not in your immediate custody and control anymore. If the police are there, they look past you and see a gun sitting there, they can charge you because it's not within your complete custody and control. Also, a question was posed to the sponsor of this bill. What happens in the middle of the night that I get up and I walk to the bathroom and I leave my gun by the nightstand? Am I committing a felony? Am I violating this section of the law? Technically, you are. So do you want to be able to be going into a court and saying, how far is too far away? Is my kitchen too far away? Is the bathroom too far away? Is the next room too far away? What happens when you start storing these firearms and they're put away and then somebody breaks into your house? You're going to say, hold on, wait a minute, I got to go and I got to unlock the safe, load a firearm, then Mr. Attacker, then you can come in. The wording of this bill is terrible. What ends up happening is you will be forcing people into court, and judges are going to be determining what is within your custody and control, and did you relinquish that? So it's worded terribly. So you need to really fix this. But everybody says, a great bill, you got to have it. This is why you need the experts to come in and tell you people the way this is written, all you're going to do is have people in court being subject to being challenging a felony charge against them because somebody determines that it's not close enough to be in your custody and control.
Thank you. Senator Taquan.
Thank you, Madam Chair. Sir, one of the bills you referenced was S2446, had to do with NIBIN, and you mentioned that it was an unfunded mandate. Could you explain to me how you came to that determination?
Whenever you tell the police departments they have to do extra jobs, they have to do extra things, they have to make sure they're creating a database. Now they have to do taking custody of a firearm, now taking and putting it into evidence log that they took 2 rounds, they fired it, they have to... all this stuff requires a police officer's time and effort. Where is the extra money going to be for the extra time and effort that's going to go into that? You're going to be sending all of these all these guns, all of these rounds down to the crime lab. Who's going to be paying for that? You got to create a database on that. You have to store all this information. Who creates that? Are you going
I didn't ask you who created it. I asked you, how did you determine it was going to be an unfunded mandate? Because as far as I know, the ATF does this for free for all law enforcement agencies across the country. So in terms of an unfunded mandate, I just don't see it. Also, it's part of an investigation, so they're collecting the shells anyway, just asking them to submit them for forensic testing through ATF. I fail to see how it's an unfunded mandate when it's offered free by the FBI.
Okay, so they take my firearms and they go down and they test them and they put in...
They don't take your firearms, just the shell casings, sir.
They have to fire them through the weapon to actually get a trace on the actual round, the projectile that comes off. They don't just take a shell casing and put it down. They actually have to test fire it.
That's correct.
Correct. So they're taking my firearm to a facility. They're test firing that, and then if I get cleared of the charges, my firearms, that list, I'm on that database. Is it coming off?
Thank you.
Okay.
Thank you, Senator. Senator LaMountain.
Thank you, Madam Chair. Frank, welcome. I always appreciate your input on these matters and always consider your expertise. However, as it relates to Senate Bill 2788, the Attorney General bill sponsored by Senator Casada, you had mentioned sealing. This bill does not affect sealing. Obviously, sealing is for cases that have been dismissed. Obviously, I share your concern if this bill did go to that extent to represent cases that have been dismissed and sealed, especially those that kind of relate to the fact that the Attorney General is unable to prove an allegation against somebody. However, this bill goes forward and expressly concerns expungements. So an expungement, as you, I think, are aware, this happens after a conviction or a plea or somebody accepts responsibility for a crime. And this bill, as the way I read it, adds to a list of exceptions. Generally put, an expungement allows an individual to say they've never been arrested or charged or convicted of a crime, even after a conviction, if it's allowed by the court. Here, certain individuals have to express that conviction, even if it's been sealed by the court. We talk about admission to the bar, if somebody's applying to be a law enforcement agency, a teaching certificate, a coaching certificate, an operator or employee of an early childhood education facility. And this just adds simply, if you're applying for a license or a permit to carry a concealed weapon under Rhode Island general laws. And in that small circumstance, is adding that if you want to be a coach, or if you want to work at a daycare facility, you have to tell us if you've been convicted of a crime and it's been sealed by the court. This bill just seeks to, separate from the case that you argue before the Supreme Court, that said if you have been convicted of a crime, we want to know about it. And I think it's a reasonable request from the Attorney General for the police departments to look at it, because they also look at other issues, right? Any call logs, any other, they request mental health issues. So they want to know who is the person applying for this concealed carry permit and the extent that they've had a criminal conviction and whether that's relevant or not. So I just wanted to clarify that. It's not really a question, more of a comment.
Okay, can I address
Senator LaMountain.
Can I address that?
Go ahead,
Okay.
briefly, please. There's a couple other questions from committee members.
So what happens is normally under the expungement statute, if you take a look at the language, what happens when a person applies and goes in front of the judge and says, I paid back my debt to society. I've done everything the court has asked me to do. I've waited the time period on this. I want to have a clean record again. And then the judge orders that and says, all of your civil rights are going to be restored. This creates an exception when now you go to apply to a concealed carry weapons permit. It could be 10, 15, 20 years ago. The Attorney General now wants to know all of the facts and circumstances on a case that a judge has ordered that all your civil liberties are back. The Attorney General's office, and one of the reasons why I took it to the Supreme Court, is the Attorney General's office was looking at an unsupported allegation in a report and utilizing that to deny somebody for a concealed carry weapons permit. What do you think is going to happen for something that's been expunged 10 years ago? The Attorney General is going to look at that and go, well, I don't like what happened 10 years ago, so I'm denying you the concealed carry weapons permit. What would be the person's recourse? Because we don't have an appeals process in Rhode Island, a writ of certiorari to the Supreme Court. I've already done that. This is why this exception is terrible. When a judge says you've paid your debt to society, we're sealing all your records or expunging it, your civil liberties should be restored, not be exposed and go back to the Attorney General's office so they can use them to deny you. That's what this bill is about.
Madam Chair, a follow-up.
Senator Lamont.
I just respectfully disagree, unfortunately. Again, I don't want the issue to be confused with when a case has been dismissed. I agree with you when a case has been dismissed. It should not be used against somebody for their application. This is for somebody that's been convicted of a crime, either after trial or by plea, and we've already have exceptions to that. I understand what you're saying. When it's been ordered by order of a court, expunged and removed from public inspection, that file still exists. The public just can't see it. Because we can use it for sentencing purposes and a whole litany of other exceptions. And we already have the exceptions, what I went through. This is simply adding that to that list. Thank you, Madam Chair.
Thank you, Senator Lamont. Leader Dela Cruz, did you have a follow-up?
Yes, I just, Mr. Sakosha, as a legal expert, how does the Bruin decision impact your opinion on the assault weapons ban legislation?
It's absolutely unconstitutional. The ruling of Bruin is very clear on its face. The United States Supreme Court stated very clearly, if there is a challenge in any court to a piece of legislation that restricts in any way someone's Second Amendment constitutional rights, the burden then shifts immediately to the state to prove a national traditional historical basis back to 1791. That's it. If there is no basis back to 1791, then the legislation or the restriction will fail. The reason being is the United States Supreme Court has put back into place the plain and clear language of the United States Constitution. The right of the people to keep and bear arms shall not be infringed. That's what it means. It's very clear on its face. What happens is you hear people that come up here and say, well, I'm an expert and I do this and I do that. Well, actually, some of us actually litigate this. What ends up happening is this. When you take a look at the Heller decision, the two-step balancing test in Heller has been overturned. So you can't bring in governmental interest, gun statistics, whether people think this is going to feel better or not. Those are no longer considered to be part of the legal analysis. So if you take a look at the new decision that just came out in the First Circuit, that judge clearly went around the Bruin decision and stated, this is a unique circumstances where we're going to support the governmental interest based on, mass shootings and other things. That was specifically overturned or overruled in Bruin. That decision will go to the Supreme Court because the analysis under the Bruin decision is very clear, very straightforward. You need to have a basis for the restriction on a Second Amendment right.
Thank you. Senator Rogers, did you have a follow-up? Okay, thank you. Any other comments or questions for the witness? All right, thank you for your testimony. Welcome to the committee.
Thank you. Madam Chair and members of the committee, my name is Curtis Pouliot-Alvarez. I'm an assistant public defender and the legislative liaison at the Office of the Public Defender. I'm here to speak on three bills quickly. Senate Bill 2676, 2733, and 2734. As to 2676, the Office of the Public Defender opposes this piece of legislation. Mandatory minimum sentences are bad public policy because they raise the costs of the criminal legal system, and by virtually all measures, there is no evidence that such sentencing schemes have any meaningful impact on crime rates. By stripping judges of their discretion, these sentences fail to account for the nuanced, for the nuanced circumstances in each case, treating all offenses of a particular nature with the same severity and allowing prosecutors to predetermine the sentences that will be given. We believe that trial court judges are in the best position to make the highly contextual, fact-laden decision about the proper punishment in particular cases. And trial judges have the benefit of experience in reasoned, transparent discretion, making them the precise individuals who should decide the complicated, fact-specific issues of sentencing. Furthermore, mandatory minimums have been shown to disproportionately affect minority and low-income communities, perpetuating systemic inequalities within the criminal legal system. Additionally, that brings me to Senate Bill 2733. This bill, we do have concerns because it does reiterate the use of a mandatory minimum for sentencing. But I'm going to focus my testimony on the apprehension of extending the class of prohibited persons to all individuals with any felony conviction, as opposed to our current law that is narrowly tailored to individuals that pose a safety risk. This bill would dramatically expand the stripping of the right to bear arms. Currently, 1147.5 has been carefully crafted to prohibit the possession of firearms by those convicted of crimes of violence, are fugitives from justice, have committed felony domestic offenses, or have committed certain misdemeanor domestic-related offenses. The careful selection of these disqualifying offenses represents an appropriate balancing between the right to bear arms with the risk a person poses to public safety. This proposed amendment would greatly expand the disqualifying offenses to include all felony convictions or pleas of nolo contendere that don't qualify as convictions traditionally, if they are crimes of violence or not, and without any relation to public safety. I had more, but I'll stop there.
Thank you. And if you want to submit anything via writing, we'll make sure to review it.
Thank you very much.
Senator Rogers.
I'm perplexed on this. This goes back to Senator Lamounta's question and back and forth, correct? On that bill is the one you're talking about with the, I think, is what your discussion is? Oh, was it? All right.
No.
I apologize.
Thank you. Thank you for your testimony. And next up, we have Brenda Jacob, Robert Church, and Michael Luciano. Welcome to the committee. We'll start on my right, your left.
Thank you for having me here tonight. A lot of my testimony has already been discussed, but I did want to bring up some points. First of all, my name is Brenda Jacob. I'm lobbyist for Rhode Island Revolver and Rifle Association. I urge you to support Bill 2103, 2107, 2108, 2111, 2201, 2216, 2231, 2451, 2676, 2199, and 2658. I believe all these bills address common sense approaches to crime, appropriate punishments, public safety, and clarifies definitions. I'm also here today to oppose Senate Bills 2202, 2218, 2219, 2653, 2246, 2733, 2734, and 2788. I'm going to specifically talk about safe storage first. One of the things that has not been mentioned tonight is that if you have never been in a situation where you've had to defend yourself in a panic situation, you can't possibly understand how long it takes to open a safe. And I have been in that situation on 2 occasions. I also want to talk as an instructor for women. We instruct a lot of domestic violence survivors, and these women come in, they learn about firearms, they go through all the proper permitting process, they go through all the waiting periods, they do all the right things, and by the time we're done training these women, they feel empowered that they can finally get their lives back in order. And now you're going to tell them that they have to lock up their guns and not be able to have quick access to them in the event of an emergency. And even more so, the attackers now are going to know that those firearms are locked when they're in their house, and a house that they're most of the times they know intimately. So we strongly oppose that bill. 2219, the one firearm in a 30-day period. That is a infringement with negative consequences. And as an FFL holder, I can tell you that we have, on many occasions, we have taken firearms in divorce situations when children in the house have developed a drug habit or mental health issue. And we've also done transfers in the death of a family member. So that bill would significantly infringe on those scenarios where we are trying to be helpful in situations, especially divorce. You know, people are going through a divorce, and a lot of times we'll transfer firearms to another family member so that the firearms are not in the house, and that is to prevent any tragedies from happening. And that would completely infringe on that because we have to do legal transfers in order for those firearms to be removed from one house to another. And in the case of a death of a family member, there's a lot of people out there that have large collections, and they have, in their will, have distributed to other family members, and we take care of all the legal transfers in that, and that would absolutely deter that as well. And that would also encourage people to not want to bother with the law and just go ahead and take, and then you will have untraced firearms within the community. And I don't think that that's the intention of this bill. The assault weapon.
Finish your final thoughts.
Okay. The assault weapon ban, that is just a very deceitful bill by definition. It's grouping in too many firearms. That should not be included at all as an assault weapon. You're using safety features and making them into components that they're not intended for. And I do want to answer Senator De La Cruz's question regarding polling. A lot of these polls that you're hearing about today, if you go to the Rhode Island Coalition Against Gun Violence website, right at the bottom of the page, it will say 600 Rhode Islanders polled. And with 70,000 hunters in this state, I don't think that's a fair representation of the citizens of Rhode Island.
Thank you. If you have additional information, you can send it to us. Are there any questions or comments for the witness? Leader De La Cruz.
You know, I know that you don't like the bill, the safe storage. A lot of people don't. I'm just wondering if maybe you reach out to the bill sponsor and ask her to amend the language, not only because it's incredibly vague and open to interpretation and really ready for litigation, but also to exclude individuals who don't have children in the home. You know, they're single, they're married, but no kids. I know it's not a good bill, but maybe it makes it just a percentage better. It's just something I was thinking about.
Okay. Thank you. Are there any other questions or comments for the witness? All right. I don't see any. Thank you. Welcome to the committee.
Can you hear me now? Okay, my name's Robert Church. I'm from Tiverton, Rhode Island. Been a resident of Rhode Island most of my life, and an avid sportsman. I was competition target shooting and whatnot, hunter. And I worked in an armory for a couple of years on a military base, so I know something about weapons too. A little bit about the AR weapon, or what you like to call the assault rifle, really Armalite rifle, that shoots the 5.56, but called used tonight, you could shoot a .223 out of it. At the same time, they were saying this round was so deadly, so lethal. Well, any round can be deadly or lethal if put in the right spot. I can tell you a story about a grandma who killed a black bear with a .22 rifle. As the bear stood up, she shot it in the armpit. It hit the brachial artery, and the bear bled out. Any type of round can take a life. As far as that round right now, on that's commonly used in the .223 and the 5.56, think about this: you cannot hunt wildlife with that round. Ask most states, most public game wardens and whatnot in the state laws, the round's too small. It's too small for big game. By big game, we're talking about deer, things like that. No, we're relatively sized deer, aren't we? Why can't you use it? It's not that effective of a round. You can carry a lot of it. The military was good for that. You could carry a lot more rounds in battle, but that was it. Now, as far as ARs inside of schools, which school right now has the most fatalities? School fatalities in the shooting. How about Virginia Tech? And you can look it up. What did the shooter use? He used 2 semi-automatic pistols. Look it up. Highest body count. Again, any gun can kill. Any gun at all. The AR is a semi-automatic rifle. That's all it is. It's a semi-automatic rifle. It's not a weapon of war. It doesn't have that selector switch. And I can tell you, once you start tearing them apart, an actual military rifle has a lot more steel, a lot less plastic inside of it. Now, back to the school thing again. I think if we really want to protect our schools, let's keep going with the school officers. How about some metal detectors? And how about this? Locks that can be locked. If not by the teacher, by somebody else. Sandy Hook School, a friend of mine was a Connecticut State Trooper. His best friend from his barracks, State Trooper also, his kids went to Sandy Hook. The very first classroom that the shooter went to after he killed everyone inside the office, his kids were inside that class.
Please finish your final thought.
My final thought, every one of them kids lived. Why? The teacher locked the door. It speaks volumes, doesn't it?
Thank you. Are there any questions or comments for the witness? All right, thank you for your testimony. Welcome to the committee.
Hi, my name is Mike Luciano. Mike Luciano from Cranston, Rhode Island. I just wanted to point out on Bill 2653, there's really no such thing as an assault weapon. The term assault weapon is a made-up term. I challenge everybody to do a search on the term, and it will not bring you to any manufacturers of modern sporting rifles. None of the features listed in the bill make a firearm more dangerous. A grip gives you better control. Flash hider reduces the blinding of the user and does not mask the gunfire from observers. A collapsible stock allows the user to adjust the fit to them for better and safer control. Having a magazine's outside of the grip is just a feature. It's just the way this firearm has been designed. On the Bill 2202, the safe storage bill, there's already a law on the books that covers guidelines for safe storage. In the past, the Speaker of the House proposed a plan to create a tax incentive for people buying safes. I believe that's a good addition to the current law. I suggest that if that addition is put in, then work with the local media to promote this type of plan, to let people know that they can get a tax incentive for buying safes. You can't legislate within people's houses. Reckless people are going to be reckless. As far as in general on gun safety and gun deaths, I hear all this talk about children, but the fact of the matter is a majority of these children are gangbangers, kids that are involved in crime themselves. They're not innocent little kids like these people want you to believe. Mental illness and a breakdown of the family unit in this country is the problem, and you don't have to look farther than our President Biden for that. Concerned about child safety, well, you guys are all protected with armed guards, but yet the General Assembly will not spend one nickel to make sure that police are in every single school, metal detectors, and camera systems as they should be. We protect you guys. How about the kids? Everybody's concerned about child safety, but they don't want to spend money on police in schools and make sure that the children are protected. We protect banks, we protect lawyers' offices, all the government buildings in the state. But children, you just want to complain about how children are at risk, but you don't want to help the situation. That's where the solution is. Not punishing people like me who go punch holes in targets every couple of days, every week, once a week or whatever, because I'm retired. We're not the problem, but you want to punish us and put us in prison, but you don't want to protect the children. Thank you.
Thank you. Are there any comments or questions for the witness? All right, I don't see any. Thank you for your testimony. Next up, we have Winthrop Reed, Tanya Pereira, Alfred Arlen. Let me call a few more names, sir. Daniel Patterson, Harold Borders. Come on forward. Thank you. All right. I'll go back to you if I called you and you just came in. I'll go back to you. If you want to introduce yourself, sir, we'll start on my left. Let them get settled in.
You gonna start with me?
Yeah, I'm going to start with you. If you just want to let us know who you are, so I can make sure that I.
How about now? There we go.
Yep.
My name is Dan Patterson. I'm a resident of Exeter. I am a licensed federal firearm holder. I'm also, I'm going to just put this in for one reason. I'm the town council president in Exeter because of one thing about constituents that Ms. Dela Cruz brought up. I'm only going to hit a couple here because a lot of what's already been said, no need to repeat it. I'm here to speak against S2219, 1 gun a month, S2202, safe storage, and S2653, the assault weapons. And one thing that was brought out is about this poll where an overwhelming number of Rhode Islanders are in favor of all this gun control. I'm going to reiterate what was said a few minutes ago. That poll in a state that has 1 million residents was only 600 people. Not good numbers. I'm also going to call out the individual from the AFL-CIO. I've been involved in the heavy construction industry my whole life. Hundreds and hundreds of people I know that are union members, and when they're hearing what this union is doing to them, they're not happy. With the safe storage bill, this here, on the 11th of March 2024, it was the Southern California First District Court just ruled that 1 gun a month was unconstitutional. On the assault weapons bill, as I go through this one gets scary. And I'd like to ask, who actually wrote this bill? Can anybody answer that? Who drafted it, the language? And gun registration against the law. $25 per gun. Gun registration. History repeats itself, and I'm not going to read all of this, but if you go back into gun control in Germany starting in 1919, and when you look at their gun control that was brought out in 1928, weapon purchase permits were introduced, which only allowed authorized persons the purchase and possession of firearms. Mandatory registration of weapons was introduced, which gave the government the opportunity of accessing weapon owner and their weapons at any given time. Manufacture and sale was only permitted if authorized so. The purpose was to ensure that firearms were only issued to reliable individuals. 1933, when the Nazi Party took over Germany, these lists were used to go out and confiscate every firearm from unreliable and the way I'm looking for the exact word that they used other than unreliable. But they went after the Jewish population and took all their firearms. And in 1938, they started to round up those same people. That's about all I have to say for this.
Thank you, sir. Any questions or comments for this witness? Welcome to the committee. If you state your name, please, and proceed.
Name's Alfred Holland, Warwick, Rhode Island. I'm a certified NRA instructor, and I'm here in opposition to bills 2201, 2202, 2218, 2219, 2231, 2653, and 2734. I'm just going to speak on 2218 and 2653. First one, the testing on 2218. It's probably a good idea. I mean, we have that with the blue card for just handgun purchases in the state as it exists now, and it overlaps into the purchase of ammunition in the state. However, to expand that out is also not a bad idea. However, the problem with this is every 2 years, you're going to review the information again with the same individual, and every 2 years after that. To what end does that serve? I don't see any purpose in that whatsoever other than just being harassment. It is, and just a harassment to Second Amendment believers, to conservatives, to even Republicans if you want to go down that road. And it's nothing more than an act of harassment, a one-time deal, When you get your driver's license, do you have to go back every 5 years to 2 years or every 30 days to review your driving ability and your driving knowledge? No. If you propose that legislation, I guarantee you the roof on this building would wind up in space. It would not stand at all. Why should we accept it for firearms? Once you learn it, you learn it. You either know it or you don't. And there's no purpose in dragging it out and turning it into harassment just for the sake of turning it into harassment for political purposes. 2653, the assault weapons ban, you're taking a common device which works like every other common device in the firearms world and turning it into the boogeyman is what you've done. You've demonized it. You're sitting there and saying, if it weren't for that, these school shootings and these other happenings would never happen. Well, that's no. That would, if anything, you would encourage the crazies and the criminals to use another means. I mean, in Japan, but 15, 20 years ago, a religious group in Japan released sarin gas into the subway system. How many people did that kill? And how many AR-15s or AKs were used in that? None. What's the purpose? Singling out the boogeyman is not going to make it go away. It's not going to solve anything. It's not going to stop any of that. And if anything, they'll just encourage those who would commit these crimes to use another means to do what they're going to do. That's basically all I have to say.
Thank you, sir. Any questions or comments for the witness? Sir?
First of all, I say hello to everyone. I'm glad to be here again. My name is Harold Borders. I was in the Marine Corps for excess of 20 years. And honestly, to be honest with you, I take offense to people describing an AR-15 as an assault weapon. Now, what I'm going to say sounds a lot about what people already said about it, but I just got to get it out of my system, okay? It's hard to sleep at night. Listen to people describe something that's basically modified 22. Okay, second of all, when I was in the Marine Corps, I taught hand-to-hand combat. I taught people how to shoot their rifles in the Marine Corps. And knowledge is power. I was born in Georgia. When I was born in Georgia, everybody had guns, okay? We knew better than to mess with guns in the house. We knew better than that. Our parents taught us how to handle them. My grandparents did. Responsibility. And now it's like, here we go again. I just got to read what I wrote. Okay, here we go again, fighting for something that our framers of the Constitution gave us, the Second Amendment of the Constitution on 15 December 1791, which protects the right of Americans to protect themselves, their rights, and their property. And it reads as such: a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms, what am I about to say next, shall not be infringed. I don't know about you, but it sounds pretty clear to me. For those sitting there and making these big decisions, did you swear on an oath to protect and defend the Constitution? If you believe in the Constitution, you should be recognized for that, okay? Does anyone up there believe in being honest, believe in integrity? Again, you should be recognized for that. Well, here we go again. Now, I was here the last time, which I'm going to be honest with you. My mother and father taught me to always be honest, to show integrity, okay? Honestly, the last time I was here was the time, that little deal with the magazines. I was the one, I don't know if you remember me, I was the one that bought the 30-round magazine then, okay? And I laid down on a table and I said, if you think an object can be moved by mind power alone, I gave everybody 3 minutes to use all your mind power to make that magazine move. It didn't move, it stayed in place. What does it take to make the magazine move? An evil person that wants to do damage on someone, okay? An AR-15 can sit in your closet all day long, for months, for years, and you can't, if you want to use it for something bad, that's on the individual, not the object. And first of all, what does the word assault means? It's an action, not an object. And I'm not trying to knock what a lady said about a fully automatic weapon, but let me tell you something. AR-15 is not an automatic rifle. It's a semi-automatic rifle. Military weapons are the only weapons that are full automatic. It has a select on it. So when you say assault weapon, I want to see a weapon with a switch on it that can be turned into a fully automatic. And unless it has that, please don't tell us we have a doggone assault weapon. That's all I want to say. Thank you.
Thank you, Mr. Borders. Questions of this witness?
Any questions?
Thank you.
Okay.
We'll now call a panel of Matthew Malloy, Luis Vasquez, and Jeff Gross. Starting from my left, your right, sir. Welcome to the committee.
Okay. Thank you for having me. Just want to share a few words, a different perspective, I guess. In a time where democracy is under threat, why do we seek to restrict constituents? Historically speaking and globally, gun control has been the preamble or has led to fascist policies in governments. For example, many Central American nations have faced periods of political turmoil and authoritarian rule. In such context, gun control measures have been used as tools of oppression by governments to suppress dissent and maintain in power. Central America has experienced significant armed conflicts, civil wars, and insurgencies. In such environments, access to firearms has been crucial for both state and non-state actors. We can see the correlation given in the current political climate this country has today. The so-called term assault weapons is vague, misleading, and often used to demonize firearms that are no more dangerous than any other. Banning these weapons would do very little to address the root cause of violence in our communities. Instead, it would penalize law-abiding citizens who use these firearms for legitimate purposes, such as self-defense, sport shooting, and hunting. The numbers of firearms in circulation makes effective enforcement difficult. Also, criminals by definition don't follow the laws. They will find a way to get firearms regardless of any bans. We see there's been a few shootings in Providence and Cranston where they used 12, 15-round magazines. I thought those were illegal as of last year. Criminals don't follow laws. We should focus our efforts on tackling the root causes of violence, such as mental health issues and socioeconomic disparities, rather than targeting inanimate objects. Moreover, let's not forget the Second Amendment, a cornerstone of our Constitution, and what makes this country unique as opposed to many Central American countries. For example, it enshrines our right to keep and bear arms, not just for individual protection, but also as a safeguard against tyranny. History has shown us time and again that unarmed people are vulnerable to government overreach. We must preserve our right to defend ourselves, our families, and freedoms from any threats, especially now where there are presidential candidates that threaten the very fabric of our democracy. I urge you to reject this proposed legislation. It's not the solution to our societal challenges. It's a knee-jerk reaction that undermines our liberties and fails to address the real issues at hand. Instead, let's focus on fair, responsible, and evidence-based policies that promote responsible gun ownership, improve mental health services, and address the root cause of violence in our communities. All this legislation does is put restrictions on people, it limits ourselves, and it creates law-abiding citizens, it makes us felons. Thank you.
Thank you, Mr. Vasquez. Questions, comments for the witness? Thank you. Sir?
Good evening. My name is Matthew McCoy. I'm a resident of North Kingstown, Rhode Island. Senator Alana DiMario is my representative in the Senate. I am a volunteer with Moms Demand Action chapter in Rhode Island. I'm a veteran. I served 23 years in the military. And during my time in the military, I was trained to use and did use various types of firearms, including semi-automatic and automatic weapons. I am a supporter of Senator Loria's safe storage bill and Senator DePalma's assault weapons ban. We have been here before. This is not the first time I've testified before this committee. This evening you have heard from law enforcement, you've heard from union officials, you've heard from educators, you've heard from children or child advocates, You've heard from basically all the same people who have testified before this committee in previous years. None of what you're hearing this evening in this hearing is new. Most of these bills that you're considering are not new. They're just reintroduced this legislative session. So really what we're here for tonight is to ask the question, do you have the political will this legislative session to move these bills to the floor for a vote by the members of the Senate? Because I believe that the members of the Senate will pass these safe storage bills and the assault weapons ban bills if they are presented to the floor for a vote. And if you don't pass them out of committee, I'm sure that the bills will be introduced again next year, and we'll do this gun night again next year, and you'll hear all the same testimony that you heard this evening from the same people, from the same advocates, the same proponents, and we'll do this all again next year. Thank you.
Thank you. Are there any comments or questions for the witness? All right. Seeing none, thank you. Welcome to the committee. Go ahead.
My name is Jeff Gross. I'm a Rhode Island resident. You may remember me from last year. I'm the one that brought up 18 U.S. Codes 241 and 242. Well, just to be sure for my testimony tonight, I checked the FBI and DOJ website. It specifically mentions politicians and, surprisingly, judges that fall under those jurisdiction of 241 and 242 of infringing the constitutional rights of Rhode Islanders and American citizens. Now, that said, I'm testifying against 2202 and 2653. Both are clearly unconstitutional by the Bruin decision, which reaffirmed Heller, which reaffirmed the U.S. Constitution. End of story. This 86-year-old grandma refuses to turn in her firearm. That's her defense against anybody of any size. She will not lock it up and make it unusable. Why? 1791, there were no laws stating that she had to lock up her firearm or that put any restrictions on any kind of firearm that she owned. She used to be a Democrat of the JFK era, not anymore. With 18 U.S. Codes 241 and 242 in mind, and 1147 being 95% unconstitutional, with the exception of somebody committed cold-blooded murder. Nobody would stand for that. I've joined forces with the Second Amendment Foundation out of Bellevue, Washington. Currently, we have a class action lawsuit against Massachusetts anti-gun politicians. And we are suing them personally, not as a state body, personally for their red flag and restraining order laws. This class action lawsuit is for hundreds of millions of dollars, possibly $1 billion, because one cannot put a price on their inalienable rights. These rights are priceless. It is my personal goal to bankrupt as many of these anti-gun Massachusetts politicians as possible. I wonder how many in a couple of years will ask themselves if the anti-gun movement was worth their life savings. Thank you.
Thank you. Are there any comments or questions for the witness? All right, I don't see any. Thank you so much. Next up, I'm going to go back to some folks that I called previously. I think they may have come into the room. Paul LeBon, Michael O'Neill. I don't know if we got Winthrop Reed while I was out in the hallway or out getting dinner. Yep, coming up, Tanya Pereira. And then we have Ariana Wall and Lydia Davis. All right, come on forward if I called your name. Paul Poplack, apologies for that. Ma'am, we'll start with you. Welcome to the committee.
Thank you for your time. My name is Tanya Pereira. I'm a lifelong Rhode Island resident.
The button should be up.
Oh,
There you go. Thank you.
Thank you. Thank you for your time tonight. My name is Tanya Pereira. I'm a lifelong Rhode Island resident, and I'm very concerned for my safety and my family's safety. Crime rates are rising, court systems are overwhelmed, and criminals are becoming more emboldened. As a new mom, I need to look at the most effective and sure way to protect my son should harm come our way. The only tool that will ever even the odds against the armed criminal element is my firearm, period. So what will I do? What do? I have a firearm, and I train to be proficient. I train with pistols, rifles, and shotguns. I get my heartbeat high to simulate adrenaline. I use a bag of rice to simulate holding my son. I do everything in my power to ensure that I am able to protect myself and my son. The safe storage bill introduced should be relabeled as an anti-self-defense bill, because that is exactly what this does. No doubt I am going to keep dangerous items away from my son until he's old enough to learn how to use them proficiently and safely. I'm not irresponsible. But do the senators supporting this bill suggest that I ask the armed men kicking my door in to please wait for me to go to the other side of my house and unlock my firearm? Maybe the police will get there before they finish kicking my door in. Well, that's not what happened a few days ago in Providence. When something like this happens, only a few seconds matter. And no matter how good the police are, they can't be there in time. An extra 1 to 2 seconds is all a criminal would need to overpower someone like me. Padlocks, mechanical locks, and biometric locks all add time that I don't have when I need to defend myself and my son. This leads me to the so-called assault weapons ban. This would essentially ban the majority of long guns and even some pistols and shotguns. You've heard multiple times how this is a violation of our state and federal constitution and does not pass the Bruin test, so I won't reiterate. If you're not familiar with firearms, the 8 pages of restrictions might be quite hard to digest. Once you start digging into exactly how something is deemed an assault weapon in this bill, it's very concerning to me that it's based on safety features, such as a folding or a telescopic stock. A telescopic stock makes it safe for a smaller framed person, like me, like most women, to be able to shoot the same long gun as a 6-foot man. A pistol grip allows you to more effectively and safely maneuver a long gun. A shroud around the barrel stops you from being burned. I don't understand why you want to ban firearms with basic safety features. It doesn't make any sense. In summary, I feel, as many of your constituents feel, that these bills will put my family and myself in danger, restrict my constitutional rights, and ring the dinner bell for armed criminals. Thank you.
Thank you. Are there any questions or comments for the witness? All right. Thank you for your testimony. Welcome to the committee.
My name is Letitia Davis. I'm from Exeter, and I've been up here for years testifying against a good number of these bills. First of all, there's one reason I'm able to be here, and that's because somebody protected me with a gun. It was not locked in the safe. It was right by the bed. And when you are under attack, 1 or 2 seconds is an incredibly long time, and you don't have that time to waste. One of the things that seems to be missing in so much of what I hear is all the talk is about, we're going to save these lives, we're going to protect these people by restricting guns. But where are the statistics on the lives that are saved? I think my life counts. I don't understand how making access to our guns is going to make it safer. It's like so many things nowadays, vocabulary is turned on its head, and words seem to be treated as exactly the opposite of what they mean in the dictionary. Safe storage, that's not safe for me. The safe storage law doesn't have any acknowledgement of people who might have mobility issues, might have arthritis, any restrictions like that. And it's telling us to spend money that people might not have. and it doesn't take into account where the location that a safe might fit in your house might be compared to where access for somebody coming into your house might be. So you might not even be able to get to the part of the house where the guns are stored. So I'm absolutely opposed to that bill. Recently, there have been 2 states that have finally passed constitutional carry. We're up to 29 states now. We wouldn't need some of these other bills that have to do with correcting our permitting process, our permitting application process, if we acknowledged constitutional carry. Why is Rhode Island so far behind the other states? People are recognizing in other states that the Supreme Court, has passed a number of decisions. Constitutional carry is what we should be doing. It's our right. It isn't a right that comes from the state. It's our right. It comes from God, and it comes from our Constitution. When I look at things like 2788, the Expungement Act, it looks to me like it's a hidden registry. It looks like a hidden way of preventing people from getting guns in an underhanded manner on the part of the people that are controlling that. And this has been an issue for a long time in Rhode Island. It was a problem in Exeter where we don't have a police force, so it's even more essential there that we have firearms available. Thank you for the opportunity.
Senator Rogers.
Thank you, Jim. We put out a lot of statistics tonight. You mentioned constitutional carry. 58% of the United States have constitutional carry. 58%. Thank you.
Thank you. Are there any other comments or questions for the witness? All right. Thank you so much. Welcome to the committee.
Hi, my name is Paul Pavlak from North Kingstown. Bridget Valverde is my representative in the Senate, and I'm here to oppose the gun control bills. I believe it is unlikely that the ban on so-called assault weapons will do anything to reduce what little gun violence our state has. And a report commissioned by the Clinton administration, Department of Justice, was found that renewing the ban would have a, and I quote, small at best and perhaps too small for reliable measurement, end quote, effect on gun violence, and that prior to the passage of the 1994 ban, assault weapons were used in a very small percentage of gun crimes across the entire country. And as far as Rhode Island's concerned, Attorney General Peter Nerona presented figures in his March 31st, 2022 letter to Speaker Shekarchi and Senate President Ruggiero, as the Office of the Attorney General collected additional firearms data during a period from September 1st, 2021 to December 31st, 2021, from 143 firearms-related charges. And of the 174 weapons detailed in the report, only 3, which is less than 0.1%, were semi-automatics, and it is unclear if these would even be considered assault weapons under the proposed law, which seeks to ban features that do very little to impact the actual functioning and efficacy of the firearm. And for the FBI's 2019 report on crime in the United States, which is the most recent year available, indicates that of the 25 murders that occurred in Rhode Island that year, 0 were committed with a rifle. And it doesn't even specify this is assault rifle, bolt action, old hunting rifle, anything like that. And I believe that just with the recent Bruin decision, even passing this law is just setting it up for failure, since the California bans on semi-automatics and so-called large capacity magazines have just been remanded to the lower courts. And the proposed registry of firearm owners is explicitly illegal under Rhode Island General Law 114741, where you can only keep a registry of firearms if these were used in a crime of violence. That's all I have to say. Thank you for your time.
Thank you. Are there any questions or comments for the witness? All right. Thank you for your testimony. Next up, we have Daniel Hessler, Maurice Devine, and Sydney Monsterclass. I apologize for butchering your last name. And then if there's anyone else who would like to testify who I didn't call your name, please go up to the clerk because I did not have you up on my list to testify. Actually, sir, if you just want to take the last seat, we can. Okay. Looks like we only have 3 people up, so. And we'll start with you.
My name is Darren Goins. I'm the State Director for the National Rifle Association. I'm here tonight on behalf of our NRA members in the state of Rhode Island to oppose many of the bills that are on the agenda tonight. There's obviously, going this late on the agenda, there's a lot that's already been said, so I'll try to be brief and just come up with things that that I had to talk about that haven't been brought up yet. Primarily, I'll confine my remarks. I did put in a letter giving our position on several bills, but I'll confine my remarks to the assault weapon ban, 1 gun a month, and the storage bill. The assault weapon ban, I mean, we're always locked in these debates about what's constitutional, exchanges of statistics. The bottom line is these bans are largely just based on cosmetics, and the stats sort of bear that out. Where do you have, there are 9 states with assault weapon bans. There are places like Baltimore, Maryland. There are places like New York. There are places like Philadelphia. They're all places where they're plagued with gun homicides. So we can pass this bill up here tonight to say that we did something, but don't be under the illusion that it's going to make any difference. And that's the same, that was bared out with the 10-round federal ban. As far as the constitutionality of it goes, I mean, we get in this habit of saying, oh, this lower court did that this lower court did went in a different direction, let's read the tea leaves. But the bottom line is, you have to lose in order to get to the U.S. Supreme Court. And when you're pointing to losing in the 1st Judicial District, that's not a surprise. To put it mildly, that's probably the most adversarial to gun owners in the country. So what you do have to look at is after the Bruin decision was handed down, they immediately did a GVR, a grant, vacate, and remand. And they did that on magazine bans and semi-auto bans specifically. And the reason they did that is a pretty good indication that they didn't think that those bans would meet their new test. And Frank Sicoscio went through that test. So I'm not up here to predict what the court's going to do, but I think they're pretty good indications that an assault weapon ban is unconstitutional. And what I'm also saying is it doesn't seem very wise to go down that road when there are so many cases being litigated. In light of the fact that the state of New York had to write us a check for $450,000 in attorney fees, I mean, we can keep litigating stuff all day long, but it is going to get costly. On the 1 gun a month, there's only a couple points that I would bring out. Jake McQuiggan brought up one, and that is that California had struck theirs down. Again, I'm not going to go down that road, but I think it's more instructive to look at what Virginia did in 2012, where they had a law in the books for almost 10 years, and they repealed their 1 gun a month. There's also a ton of unintended consequences on that bill. And with that, I would urge you to oppose the bills that I mentioned. And of course, there are some bills that we're supporting. Constitutional carry was brought up. I'm happy to announce, as was announced previously, there's 29 states. I mean, just a couple years ago, it was 4 or 5. So it's grown exponentially. And with that, I'd be available for questions if there are any.
Thank you. Are there any questions or comments from the committee? Leader Dela Cruz.
I'm curious to hear your thoughts on the safe storage bill.
Yeah, the safe storage bill, I was hoping to get to that because I've done this for 18 years in 11 states. And a lot of the states, they've been ranging from South Dakota to New Jersey. It's quite a mix. And the states in recent years that have tried to do storage laws are like Vermont, Pennsylvania, New Jersey. And what they've all found is that they've all been included in their package of bills, stuff like banning 50 calibers to waiting periods, whatever. But the one bill that always gets pulled out of the package is the storage bill. and it's because it's largely unworkable. The only way for this to really work is that you would have to go into everybody's home and see how they're storing their firearms for that to have any preventative value. Otherwise, you're simply prosecuting people after the fact. And also consider, it's one thing if you're going after and prosecuting when your child goes to somebody else's home and prosecuting another parent. But there are plenty of cases out there, not plenty, I mean, fortunately it's much lower than advertised, but there are cases out there where you would be then prosecuting a parent who is, you know, dealing with the ultimate sentence, and that's the loss of a child. And a lot of prosecutors are hesitant to do that. So I would just invite you to look at what those states have done that do have basic mandatory storage laws on the books, like New Jersey and New York, and to see what kind of prosecutions. It's basically non-existent. But again, like I said, a lot of these bills are being pulled back. And again, I mean, states have different responses, but I think Pennsylvania is probably a good example because it's split control of government. They have a Democrat governor and the houses are divided. The bill went through it came up in front of the Democrat-controlled House of Representatives, and 4 bills were up that day, 2 passed, lost and stolen failed, and they withdrew the mandatory storage bill. So I think it speaks to the problems that this legislation ultimately has in a bipartisan way, really.
Thank you, Chairwoman. You mentioned the assault weapon, the attachments and stuff that create it. So I've taught my children how to shoot. Now I'm going to be soon going to be teaching my grandchildren how to shoot. And that what would be dictated as an assault weapon, because it has an adjustable stock that I fit to me when I shoot it, when I'm teaching my children, my grandchildren how to shoot, they get adjusted to their size. Same thing with a forward slide grip. So if I remove those 2 items and put a wooden stock on that same gun with the same .223 bullet, with the same velocity and the same damage, just by removing that adjustable stock that's specifically I can adjust for him and adjust for me, and the safety of holding that forward grip, just those 2 removed, that would now not make that an assault weapon, correct?
Yeah, that's correct.
Thank you.
Thank you. Are there any other comments or questions for the witness? All right, I don't see any. Thank you so much for your testimony. Welcome to the committee.
Good evening. Thank you for your time.
Can you just make sure the button is up on your microphone, please?
How's that?
There you go.
Much
Thank
better.
you.
Good evening, everyone. Thank you very much for your time listening to us with all of our shared insights. I am Morris Devine. I'm from Westerly. And like one of our other fellow citizens in this room, I, too, am a survivor. I'm a survivor of a shooting of a regular bolt-action deer rifle in the hands of a teenager who was here from a foreign country, adopted by parents. The guns were secured in a safe. The child figured out how to get into a safe, and we all know sometimes that when there's a system of parental controls, we all know that sometimes children can get around those controls. He was in the woods near Route 1A, taking intermittent shots at cars going by. Were it not for the windshield of a 1969 Mustang and a Bic pen rolling around on the floor irritating me on our commute home from college, as I bent down to pick up the pen, there was a loud crack. The windshield was ruined. The bullet went through approximately where my chest would have been in the seat, penetrated the back seat, wound up in the trunk. Because the person came from a sensitive country, and also, too, at that point, due to the age of the individual, largely nothing was done once it was in the hands of law enforcement. What will these laws do? Gun bans haven't stopped really anything. As we have seen earlier by another one of our citizens, when we take a look at statistics from DOJ, the FBI, and from CDC, and parse these, and we remove the overwhelming majority of self-suicides, when we remove gang violence instances and really get down to crimes committed with firearms, 3%, and that's rounding up to 3%, are committed with so-called assault-style weapons and weapons with standard capacity magazines provided by the manufacturer. Age. Why would we be restricting some of the brightest and best, and very intelligent, rapidly educated people in our society, our youngsters, 18, 19, 20-year-olds, infinite in capacity and capability? And the federal courts recently, 2 weeks ago, stated that 18, 19, and 20-year-olds are part of we the people. They're old enough to vote. They can enter into contracts. They're required to register for compulsory service, yet they are not able, in the eyes of some, to handle the responsibilities of owning a firearm of their choosing. If they're not capable of doing that, perhaps maybe we should raise the age for voting, because we all well know what will happen when a misinformed or underinformed person casts a ballot that carries the same weight as someone who's advanced in learning regarding the mechanics of civics. There's a few other things I would also like to add as well. The grandfathering clause in the legislation.
Please finish your final thoughts.
Clause. If you own it before the legislation is passed, yes, you are grandfathered with one of several options. You may register it with the police, which, by the way, is in direct, is directly contrary to the Firearms Owners Protection Act of 1986.
Sir, if you can wrap up your testimony, please.
So what we really need to do, I think, is look at, and as again has been highlighted before, a lot of the other things that are currently being settled as law or are before courts of appeal and also headed for the Supreme Court bench. I think it would behoove us to take a moment of pause before we put ourselves into a position where we will be in contempt of the supremacy clauses because we have gone down a path and now we're going to have to unwind that.
Thank you for your time. Are there any comments or questions for the witness? All right, I don't see any. Thank you so much. Welcome to the committee.
Thank you. Thank you, Chair Oyer and members of the Senate Judiciary Committee for hearing our testimony. I am Sydney Monstrin-Quas from Barrington and a constituent of Senator Loria. I'm a founding board member of the Rhode Island Coalition Against Gun Violence and have been testifying here since 2013 on some of these bills. I'm here in support of the Assault Weapons Ban 2653, sponsored by Senator DePalma, and the Safe Storage Bill 2202, sponsored by Senator Loria. I'm against a bunch of the bills, but especially 2107, the concealed carry reciprocity, and 2108, allowing permitless concealed carry. In terms of assault weapons regulation, we've heard a lot of information tonight, and I won't repeat that. One of the things that nobody has brought up, though, is that today, in terms of mass shootings in the U.S., today is the 72nd day of the year, but there have been 75 mass shootings in the United States, so more than one a day. And we know that number will continue to go up. And we know that assault weapons are a huge problem with those. I also want to clarify, earlier Hillary Salmon spoke, and she was the mom of the Providence police sergeant, and she was talking about that February 2022 incident where hundreds of rounds were fired at Providence police using 15 weapons, and at least one of those was an assault weapon based on the reports that we read about that. That shootout lasted about a half an hour, and as she said, Commissioner Perret, Chief Clements, they all said it was the that situation carried greater risk for police officers and residents than any gunfight they had ever encountered. So right here in Providence, in Rhode Island, that is happening. And in that situation that day, the police, the residents literally dodged the bullets. And the Coalition Against Gun Violence is all about public health, but when our police who are outgunned, then that endangers our public safety too. In terms of the safe storage bill, We talked about, or I heard some people talk earlier about, from 2014 to 2018, 208 Rhode Islanders died as a result of firearms, but 70% of those were suicide. That's 145 people. And if we're able to store our guns more safely, maybe some of those people would be alive today, especially when you look at children, when more than 80% of child deaths by gun suicide involve a gun belonging to a family member. And in addition, in terms of school shooters, almost 75% of school shooters acquire their firearms from the home of a parent or close relative. So a safe storage bill may help prevent suicides. It may prevent school shootings too. I grew up in a family of gun owners. I was taught to respect guns and handle them safely. I loved target shooting with my family, and I was recruited into ROTC. But gun violence hit my family hard when my cousin was murdered. His murder shattered my family, and I hope that passing bills like this may prevent families like mine from experiencing the devastating loss of someone they love by gun violence. So thank you for hearing our testimony tonight.
Thank you. Are there any comments or questions for the witness? Okay, I don't see any. Thank you all so much. That does conclude the public testimony. Oh, all right, come on forward. Okay. You just want to introduce us for yourself to the committee. Thank you.
Button up. Okay. Good evening, Honorable Chair and members of the committee. My name is Ariana Labozetta-Wool. I'm from Providence, constituent of Senator Miller, in strong support of 2202 and 2653. My written testimony names other bills that I support and oppose. I'll be super quick tonight because we're all being very patient in many ways, so thank you. As Kelsey Ball has testified, gun violence is now the #1 cause of death among children. I'm a teacher, volunteer board member of Coalition Against Gun Violence, and I am committed to protecting young people and broader public health, and I see these bills as part of the big picture. So let's hold us all accountable like we do in many other public health ways with seatbelts, indoor fire code, lead paint. Access to guns in the homes has led to a growing number of tragedies here and elsewhere. We've heard about them. So tightening the existing expectations, which exist, they're there, for storage and risk communication is logical. Look, I mourn the former students I have already lost to community gun violence, and just yesterday, 2 schools in West Warwick had to shelter in place due to a shooting outside. Fortunately, no one got hurt. I'm terrified that a community in Rhode Island is going to be the next Newtown, Uvalde, Denver, Nashville, Buffalo, Orlando, Parkland, Monterey Park, Lewiston, St. Louis. You get it. I'm equally terrified that a weapon of war purchased here will be used in another state. So far, we've been lucky. So we know that when assault weapons are used in the mass shootings, the deaths and the injuries rise. So we should do what's in our power to prevent the bloodshed, which means addressing all the factors, as some people have mentioned, and we can. And I'm not alone, and we've heard that there's high support for these bills, and it's not okay to sit idly by without trying to reduce the risks. It's about risk management. And I don't want to believe that any of you want to be the one who did. So I am proud of the common sense gun laws that the Assembly has passed in recent years, and we are making progress, and we must continue to be responsive and responsible, and I thank you for your good work. So please vote these bills out of the committee, send them to the Senate floor to pass. It's time. Let's make it very clear that Rhode Island stands for smart regulation that saves lives. Let's make Rhode Island the safest state. Thank you.
Thank you. Are there any comments or questions for the witness? All right. Late addition, if you want to introduce yourself for the committee, and you can go ahead. The button should be up.
Button up.
There you go.
So this was kind of a last second thing, biting the bullet here. I had to say something. My name is Andrew Roberts. I'm a proud resident of West Greenwich and the producer of the CAT podcast. I see members, particularly you, rolling your eyes, and if you think that was going to fly with me in the room, you're crazy. I am a little nervous, but I do not care. It is more important for me to be up here. Tragedy is absolutely no excuse for tyranny, no matter how many experts and doctors come up here and play on heartstrings, it is no excuse for tyranny. All gun control proves is that government wants to ban guns because they intend to do things the common man would shoot them for. It is really that simple. Last thing I wish to say is to all the delusional red and orange individual shirt people, imagine trusting the government after the infringement of COVID-19. Utterly embarrassing. Thank you.
Thank you. Are there any comments or questions for the witness? All right, seeing none, thank you so much. That does conclude the public testimony. Thank you both for your time. And with that, Senator McKinney moves that we pass Senate Bill 2202, seconded by Senator Basilian. All those in favor? Aye. Any opposed? No. So I believe that was, if we can get a showing of hands for the ayes, for the ayes on 2202. Thank you. And a showing of hands for the nays, just for the record for the clerk. Thank you. And that does pass Senate Bill 2202 to the floor. With that, I'd like to bundle the remainder of the bills for Senator McKinney to move to hold for further study, seconded by Senator Basilian. And just to go through the agenda so we make sure we get them all, that's Senate Bill 2103, 2107, 2108, 2111, 2201, 2216, 2218, 2219, 2231, 2451, 2653, 2676, 2199, 2446, 2658, 2733, 2734, and 2788. That has been moved by Senator McKinney, seconded by Senator Basilian to hold for further study. All those in favor? Aye. Aye. Any opposed? And the remainder of the calendar is held. Senator Chacoyan moves that we adjourn, seconded by the entire committee, and we are adjourned.